o'clock. Let's call this meeting to order. If I could get everyone to rise for a time of reflection and followed by the pledge to the flag. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Can we please go around the table with just brief introductions? I would like to properly welcome our new board member, Dane Gray. Welcome.
Thank
What
you.
a great day to join. We go around, just for those that are streaming.
Henry Brown.
Camille Lee Johnson.
Lynn Rohde, Office of General Counsel.
April Green.
Fred Newbill.
Kelly Flanagan.
Sean Granite, Office of General Counsel.
Lasikia Hodges, Office of General Counsel.
Thank you. All righty. In light of today's discussions, I'd like to make a slight modification to the agenda. I'd like to ask John Kendrick, who is our HR director, to come up after the City Council liaison comments to speak to our CEO's contract, followed by Willette Stanford, our ethics officer, to speak regarding recent alleged ethic issues, and finally, and I'd like to end with the Office of General Counsel to discuss our options. With that, I'd like to call for a motion to amend today's agenda.
So moved.
Second.
So moved by Reverend Newbill, second by Henry Brown. All in favor? Discussion. I'm
Madam Chair, if I may, to the extent that we're entertaining adjustments to the agenda, I would suggest that we also pull the matter relating to the PUP ahead of the employee personnel matters. I think that important discussions were had yesterday at City Council, and I'd like to ensure that all my fellow board members have had an opportunity to discuss those before we move into the personnel matters.
I appreciate that, but today we, let's see here. Board Member Flanagan, I agree with that. Let's go ahead and add that, move that forward. But can we have the first three? My recommendation is to have the first three fact finding first, and then we will move into the pub discussion.
That would be great.
All righty, so should I move again?
Yes, Madam Chair, I believe you need to make a
Okay.
new motion.
All righty, can I have a motion to amend today's agenda to include John Kendrick presentation, Willette Stanford's presentation, Office of General Counsel's presentation, and then we will move the performance unit plan discussion thereafter.
So moved.
Second.
Any discussion? Any further discussion? All in favor signal by saying aye.
Aye.
Those opposed do the same. Approved. All right, safety breeding, Ms. Rohde?
Yes, thank you. Safety is a core value at JEA. In the event of an emergency, may I have a volunteer to call 911? Thank you, Ms. Dykes. May I have a volunteer to alert security? Thank you, Mr. Hobson. Is there anyone in the audience who is CPR certified? Thank you, Ms. Anders. In the event of an evacuation, please be orderly, assist your neighbor. We will use the stairs to the left of the elevator to descend, not the elevator. Please maintain order, hold on to the handrails. We will exit onto the plaza and proceed to the open parking lot on the southeast corner of Main and Church Street. Please be safe when crossing the streets. For all of those in attendance, please put your cell phones on silent. Thank you.
All right, Ms. Brady, will you do Sunshine Law, public record statement?
Yes, Madam Chair. This meeting is subject to Florida's government and the Sunshine Law, Section 286.011 Florida statutes, and shall be open to the public at all times.
All righty, we have a few comments from the public today. Mr. Anthony Beeks.
Good morning.
Morning.
My name is Reverend Anthony Beeks. I'm the pastor of Mount Zion Missionary Baptist Church.
Also, I'm a member of the Baptist Ministers Conference of Duval and adjacent counties. Monday, a couple of Mondays ago, Councilman Garrett Dennis came to the Baptist Ministers Conference. He spoke about the board members that are here this morning and about the sale of JEA. His comments was disturbing to me because he said that the board members was receiving $1 billion. Well, I immediately grabbed my phone and did the calculations to $1 billion. I told all the other Baptist ministers, I said, this can't be true. It's because all kind of investigations would go forth if they was to give $1 billion to anybody. And then he talked about the board members, some of the board members, I don't know which ones, who husbands or wife might have been over the port. That the reason that the African Americans was on the board is because they were bidding the bid of the mayor. I refuted all of those things that he said, and I was very upset that a councilman would come in and he would tell those kind of lies. Also, he came in and he said that he was a big boy and he was not afraid of anybody because he carried a gun. In our city, where we have more African Americans that are killing each other over guns, and I questioned him, why would you get in here and make these kind of defamatory statements and say all of these things about Pastor Newbill and all of the board members at JEA, and you're an African American yourself? I was very upset. What I've realized to come with the president of the Baptist Ministers Conference sending out letters and attaching pastors' name to it that did not even know that he was attaching people's name to it about the sale of JEA or about the opposition of JEA, and I was very upset about it. But I'm very upset at our council person that will come into the Baptist Ministers Conference and tell these kind of lies. I'm here today, and I wish Mr. Zahn was here because he said a whole lot of things about him. The man go to work every day to provide for his family. And you would say this about people that get up every morning to go to work. These are not criminals. These are people that get up to go to work. Now, if you want to ask somebody something about criminal, you can ask me. Because before I was a pastor, and my testimony, I know I've only got about 3 minutes, I thank God for what he did for me in this city, because he took me off dope and gave me hope. He took me off the pills and put me in his will. He took me off the block and set me on the rock, stopped me from singing the blues, and started me preaching good news when I was choking from smoking and stinking from drinking. My hair was nappy, but my soul was happy. But I thank God that he's put me in the position that I am today. But I don't like what Councilman Dennis had to say to us. Thank you very much.
Thank you, Pastor Beeks. I am personally appalled. Everyone in this room knows that I am married to the port director, which has absolutely nothing to do what I do here to serve JEA. And every African American or minority on this board should be appalled. I spoke to this at the city council meeting last week, and I will say it again. Eric Green, my husband, can hold his own. We don't need anyone else. As you as a pastor know, what God has for us is for us, and no one else can disturb that. That is something we need to make sure. The allegation that anyone on this board, I can speak for myself, we don't get paid one dime. I have not received one dime, nor has any of my board members, as far as I know. I am with you. Something should be done. An investigation should be had in allowing an elected official who represents a district of people to speak on their behalf and make these kind of allegations. Thank you. Councilman Ron Salem, would you like to say something?
I sure would. That's one of the things that keep getting back to me, and Garrett Dennis' name keep coming up. That he's saying, to me, things that should be illegal, and for any African American to try to criticize the mayor because he's colorblind. We've never had on this board or any board in Jacksonville
Ever.
where we're in the majority. He was colorblind. And I think he should be congratulated because he went out and sought out people who were qualified. These are qualified people. Everyone, not just African American, all of us, we're qualified. We were business people. We were successful and still are successful. And for him to make a statement somehow that we were serving the mayor just to sell JEA is a lie. The mayor's never spoken to me about selling JEA. He's never called me, made any statements regarding that. You know, and I've got a reputation in this city for 33 years. I started serving under Mayor Hazuri and every other mayor I've served, and haven't got a dime above the table nor under the table because I've been successful enough to take care of my family and myself. And so I'm appalled as you are. And I think that really we need to be sending a letter to the city council asking them to investigate him and his statements that he's making in this community because he has confused a lot of people and create so many problems unnecessarily. And while I'm talking, I think it needs to be stated again that this board has never had the power to sell JEA. We've never had the power to sell JEA. And the news media and everybody else is hopping on, we selling JEA. That's a lie. Any decision we make on this board goes to the city council. The city council is the one that has to vote to sell JEA. And then from there, it goes to the people because the last election, we voted that the people have a say in selling JEA. So all of this confusion because the board member, Petway, who made a statement on his way out saying we need to look to the future and prepare for it because if JEA stays the way it is, then in 30 years, we're going to have some serious problems. That's all this is about. You know, now whatever else happened, investigate it. If something wrong happened, take care of it. But please let us do our job as board members serving this community and this independent authority. Thank you.
I apologize, Councilman Salem. Go
No
ahead.
problem. Thank you, Madam Chair, for providing me this opportunity. I'll make this very brief. Councilman Diamond and I held a hearing yesterday to determine the facts around the Long-Term Incentive Plan, or PUP. And I'm speaking for myself today. I'm going to make sure. I believe we made substantial progress. However, many questions remain around the origin of the plan, cost, and other issues. I will work with my colleagues on the City Council to determine the most appropriate manner to obtain the answers to those questions, which may include placing the executive team under oath. For the benefit of the citizens of Jacksonville, we must obtain all the answers. And I had not intended to address the issue of your husband, but I feel like I must. I've known Eric Green for 25 years, and I'm the liaison to the port. And I have been very impressed by his performance on that board. And any connection between you and him of some type of deal, I think is so inappropriate. And that discussion needs to stop. Thank you.
Thank you, Councilman. All right, as the amended agenda was approved today, we will move into, looks like it is item number, let's do the consent agenda first here. Oh, I'm sorry, Councilman Beckton. I'm a little, that kind of took me a little off course there. Do you have any comments today?
I do.
Please join us, please join us. I apologize for that.
No problem. I understand, and I'll just open up and say that one council member doesn't speak for all 19 of us, and I think Mr. Salem said it very well as well, you know, that we do recognize each and every one of your contributions, and I'll just say appreciate your service to this board. So with that, I have a few comments I would like to make this morning, and thank you for recognizing me, Board Chair, and good morning, everyone. I would just like to say for the board members who were here back in July, if the current environment is not what you expected during the July 23rd meeting, opening the door to a possible scenario of a sale privatizing JEA, then let me provide you some personal insight. Asking the citizens of Jacksonville for their forgiveness and not their permission, I have found to be bad public policy. In my last 4 years of experience, I have instituted this philosophy on many occasions, quite successfully, I would point out. In matters that directly affect the citizens of Jacksonville, this process should first look to educate, then to discuss, and ultimately to create a path forward that all parties can get behind. This only works if the environment that is created whereby a predetermined path has not clouded the conversation. What I am suggesting is that by opening the door in a manner that fosters open communication, debate, and provides for the ability of all to reach outcomes that reasonable people can foster results with aspects of compromise, and then and only then can we move forward. Successful communications can only work as a result of the situation not looking like a predetermined outcome and only a situation to convince. I also would like to express the fact that JEA is owned by the consolidated government of Duval County, not by you, not by me as shareholders. While the citizens of Jacksonville are recipients of the services for which JEA provide, and through their elected officials is managed, the value of this utility is not for financial gain by any individual like leadership, employees, or customers. While we are all public servants, elected and non-elected, that work in this environment by choice, benefiting by golden parachutes, enhanced value, and undeserved rebates only fosters conspiracies and outcomes that will produce negative results. I am personally appalled, along with many others, when I see hundreds of millions of dollars being given away to undeserving parties. Madam Chairman, I believe you personally asked for some type of restart the other day at the council. It would be my recommendation that this board have that conversation immediately for what that definition is to really mean. If your restart is to only look forward and forget the past, I would contend that we would all be naive to think that solves the problem and makes everything better. The citizens of Jacksonville are angry. They feel deceived, and ultimately they have the final say for which you may not like the outcome. Like the mayor, I too believe these conversations are difficult and tough. But acting in a manner that destroys public trust and confidence, and to think that we can proceed by doing the same thing and expecting different results, is not just the definition of sanity, but in the public sector is the definition of failure. I did ask Ms. Dykes at our council meeting last week the question, what can this city council do to help today JEA for the future? Not having received an answer to that question, perhaps that too should be addressed. It is my objective as the liaison of the council to you to remain objective and to leave my biasness on the sideline. But what I do not do is to approve anything that diminishes the transparency or the integrity of this process. And I would offer that for you to do the same. Perhaps in the business industry for which I spent 38 years, the philosophy whereby your first loss is your best loss, perhaps that should be the path forward. I look forward to hearing what this board thinks is the right course and the remedy in building back the public trust. And I thank you for allowing me to share these comments, Board Chair, this morning, and thank you very much.
Thank you, Councilman Becker. All right, according to the amended agenda today, we're going to move item number 4, appendix 4C, and we're going to move that to under item number 3 under discussion and action. Board Member Flanagan, would you like to give us an update from yesterday's meeting since you were in attendance?
Happy to, Madam Chair. I think that both Councilman Diamond and Councilman Salem should be commended for their looking into this matter and providing an opportunity for both us as board members as well as the public at large to gain greater transparency into some of the events that have led to today. I thought it might be helpful in framing my understanding of the plan by reviewing a condensed timeline of events from the perspective of a board member so that the general public has greater understanding of what was going through our minds at various stages of the process. So on Friday, July 19th, the board received our board packages for the subsequent Tuesday, July 23rd meeting, which has become the subject of immense focus around the PUP matter. That board meeting was a 3-hour meeting for which strategic planning was the primary focus. The topic of the PUP arose approximately 2 hours and 40 minutes into the meeting in the context of compensation committee report out. Subsequent to that July 23rd meeting, there was relatively quiet period of time with respect to the PUP if you were a board member. It wasn't until Wednesday, November 13th, that we received copy of Aaron Zahn's letter to Jason Gabriel, which had been sent the prior day, stating that JEA leadership in consultation with the chair of the board, the plan administrator, and OGC had decided to postpone indefinitely the implementation of the plan. Note that was nearly 4 months after the plan had been approved. Subsequent to that, on Friday, November 15th, the board received cancellation notice for the upcoming November board meeting, which was to be the following Tuesday. On Monday, November 18th, board members received the memorandum from Mr. Kyle Billy, council auditor. At the time, the significance of this memo was not fully understood and has become more apparent to me with the release of all of the public documentation in advance of Councilman Diamond and Councilman Salem's inquiry that took place yesterday. On Thursday, December 12th, delivery of a 466-page binder prepared by JEA management in response to the council members' inquiry was received by board members. We had the opportunity over the course of the weekend leading into yesterday to better understand what had taken place during the nearly 4 months that had elapsed between the July 23rd board meeting and the recommendation by management to indefinitely postpone the plan. I think it's important that the public know from a board member's perspective, I can only speak for myself, that at the time of the approval of the plan on July 23rd, I believe that there was a reasonably stated purpose and objective of the plan that had been reviewed by the compensation committee, which had legal confirmation that all employees could participate, that had a stated estimated cost of $3.4 million annually, with maximum targets in the framework of the plan. What's troubling to me today, sitting here having sat through 4 hours of council meetings yesterday, is that it is clear that the board did not have a thorough understanding of the calculations and resulting economics of this plan under a recapitalization scenario. And I, as an individual board member, wish that I had asked better questions at the time. The rationale that the decision to implement the plan, this is a quote from the letter that we received that had been dated on November 12th by Mr. Zahn, recommending that the plan be postponed. The rationale that the decision to not implement the plan is based in the incongruity of the plan's long-term nature and very real potential short-term implications of the JEA strategic planning process is flawed to me. It's apparent that the plan was pulled because there was greater understanding and realization that it was a poor plan. Only through the documents released leading up to yesterday's meeting did it become apparent to me that there was an original Willis Towers Watson report which describes the LTIs, or long-term incentive plans, as uncommon. That same table was later reproduced in a Willis Towers Watson report appearing in the Compensation Committee meeting materials, which were reviewed during the July 23rd meeting, describing those same LTIs as being used selectively within public power utilities. Also apparent through the documents that have been released, as early as August 23rd, management was notified by external counsel that the PUP formula is spitting out much larger numbers than we anticipated. The detailed concerns that were raised by the council auditor's office to management as early as October 31st have also been released in these documents. Sitting here today in our December meeting, looking at my fellow board members, I wish that we had had the opportunity in the November board meeting to address these matters in a timely basis. I think that we have put ourselves in a disadvantage of sitting here nearly a month later and having to answer to the public scrutiny. I appreciate the opportunity to give my perspective, Madam Chair.
Thank you, Ms. Flanagan. I'd like for the rest of my board to have the opportunity to speak. I understand you were not here, Mr. Gray, but if you'd like to add anything from your perspective from the outside looking in.
I'm going to abstain from voting on this just because I haven't been fully acclimated yet to the organization. You guys have been busy the last 30 days, and getting some time on the calendar has been a little bit challenging, so I'm going to abstain from actually the slate listed on the bottom. But I will say that the meeting yesterday and the process that we went through was very enlightening for me, just as sending from the side of a citizen. So I want to thank council for doing that.
Thank you.
Councilmember Gray, unless there's a conflict of interest in accordance with the bylaws, you may not abstain from the vote. You may, however, ask as many questions as, with the chair's permission, as you feel necessary to gain information you need.
Okay, fair enough.
Can you repeat that? I think those couldn't hear in the audience.
Yes, only under a voting conflict may a board member abstain from a vote. If that's not the case, then you may certainly, with the board's permission, ask as many questions as you need to gain the information you feel necessary to register your vote if there is a proposed action on the table.
Madam Chair, I also was not here for the July board meeting. I think my first meeting was September.
That is correct. Yeah.
And my first knowledge of the plan was the letter on November 12th from Aaron Zahn recommending it be postponed. I'd say at the time I saw it, I called him, tried to understand some background on the plan, and the way it was explained to me, I said, it's a good thing you're canceling it. That makes sense. That was the extent of the conversation around it. I guess what I would like to ask for the fellow board members that were there at the time, was there discussion at the July meeting about any impact on the plan of recapitalization, or was that just left out of the presentation altogether?
I would have to pull the minutes, but I believe so. Do you remember?
The question was asked. We received explanation that in an event of recapitalization, the plan would be accelerated, causing vesting to occur immediately at that time. What was I'd characterize as being more ambiguous is the financial impact of recapitalization on the plan. And I don't think that, speaking for myself as an individual, but I suspect the board at that time did not have a full understanding of how the calculation would work with recapitalization on the balance sheet prior to or following such event.
And so was there any number put out as far as what the payout or vesting amount would be based on recapitalization?
No,
I was never given that number.
Okay. Do we know, because I've heard so many conflicting reports and seen conflicting reports, do we have a number now on what that would have been based on payouts? Has that calculation ever become clear?
Not for me. Unfortunately, I learned what the media reported the calculations would be, but never received that from management. Yeah. And I believe it was 700 million plus.
Right. And then I've heard 200 million, which is still
Yeah.
obviously a fairly outrageous amount, but far different than 700 million. And then I've
Far
heard
different from 3.4.
and far different from 3.4.
Correct.
Absolutely. And I guess another question with that, because 3.4 was the number that was communicated during that meeting, is it fair to say that the board approved that amount and approved that given their understanding that amount would be a fair amount under the plan, the 3.4 million annually?
I would agree that I believe my vote was based on 3.4, but my vote was also based on that it had been vetted not only by the outside counsel, outside auditors, as well as OGC.
And what outside counsel, I guess, who presented to the board at that time to kind of give comfort to the board for advice of counsel?
I believe that was Attorney Kevin Hyde. Please correct me if I'm wrong. I believe that's, yes,
I spoke generally, Madam Chair, to it. May I?
absolutely.
I'm Kevin Hyde, and we are engaged as special counsel to JEA on this matter. Foley and Lardner reviewed the plan. We did not develop it. It was developed by the Pillsbury. Our primary role was looking at the issues surrounding Florida law, and particularly there's two statutes dealing with extra and deferred compensation that we were concerned about. And so following the board's approval of the plan in July, we continued our legal analysis and consultation with the Office of General Counsel, and ultimately working with Ms. Rohde, submitted questions to the Florida Attorney General to seek an advisory opinion as to the lawfulness, particularly under the section dealing with extra compensation.
It may be necessary, John Kendrick, to join us as well. Did you work directly with Pillsbury? He may be to answer more specific.
Thank you. Good morning, Madam Chair. Actually, I did not. I depended on our legal team to work through that.
Okay, so who internally worked directly with Pillsbury other than Ms. Rohde and Kevin Hyde?
Those are the two I'm familiar with.
Okay.
Madam Chair, if I may, through the chair, to address Mr. Brown's question regarding the calculation. I think at present, the facts and figures that appear most reliable would be those that have been presented by the council auditor in his report. There are a table of financial numbers that had been released within his November 18th memo. When inquiring of management whether or not they took exception to any of his calculation methodology or results, the only dispute that I have received from management with respect to the council auditor's report is that the council auditor's report was prepared on the basis of the total plan units of 100,000 versus what had been collectively understood by management as the board's action to approve issuance of 30,000 in the current year.
So, so I guess we can reasonably assume that it would be 30% of what the council auditor's report.
That's my
presented.
understanding.
Okay.
Thank you.
Thank you.
Ms. Johnson?
Madam Chair, I have nothing additional to add or ask. Thank you.
Reverend Newbell?
No, I don't have anything.
I would just like to state that my timeline is very similar in terms of my conversations and how the PUP was prepared or communicated to me as well. The thing that embarrasses me to be in this position is that I didn't learn the comments that came back from Willis and Towers about the precautions, the comments, the concerns that were given, and those were not shared with us. Whether they were heeded with or not, they were not shared with the board. And I think that would have given the board much cause, and at least pushed us into asking more questions. So if there are no further comments, do you have any, Ms. Flanagan? Can we get a motion, a resolution approving to terminate the long-term performance unit plan related to the documentations and authorizing the CEO to take any and all action to pursue the implementation of such plan and related documentation?
So moved, Madam Chair.
Second.
Any further discussion?
Madam Chair, may I clarify that you're referring to resolution number 2019-17 in the board package?
Thank you. Any further discussion? All in favor signify by aye, saying aye.
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 Those opposed do the same. Resolution 2019-10 has been,
Excuse me, -17.
previously it was 10 when it was adopted.
I apologize.
Today
Yes.
it was 20197.
Apologize.
17. All righty. Before we move on, and in light of today's comments from the public, I hope that I was able to keep my emotions together, especially when it becomes so personal, but this has been personal to everyone sitting at this table. When I started as the chair, I never imagined the obstacles that we would be faced with. I sit here today in disbelief and disappointment in the leadership of this organization. One of my biggest disappointments is we have lost a great deal of trust because we didn't exercise transparency to the community, and that is our responsibility as the board. I've been challenging myself exactly to understand just where we went wrong. I'd like to lay out a couple of points that led me to my decision today. On 3 occasions, it is my opinion our CEO, Aaron Zahn, has exercised inappropriate personal and professional misconduct, providing misleading communication that a complete review by OGC was conducted of the performance plan unit, for myself personally, not disclosing the hiring of a former board member's firm. I personally learned about this decision in the media. His inappropriate personal behavior is demonstrated by his inability to properly document or disclose any secondary employment per his employment contract. As we all know, these are just 3 issues that have come to become major distractions to this organization, and has led to a tremendous amount of mistrust with our ratepayers, the employees, and the community. Now, in light of my fellow board member's letter that was released yesterday indicating the intent to ask for Mr. Zahn's termination without cause, I would like to clarify my position. After consulting with appropriate individuals, I asked Mr. Zahn for his resignation on December 13th, that was last Friday. After initially stating to me he would resign, he subsequently began to negotiate how his resignation should be handled. When I would only accept a resignation, his counsel informed OGC that he would not resign, but requested termination without cause. Now I believe that these matters are best handled in the appropriate form, which is this meeting, and with my fellow board members. My position is, I will not negotiate. In light of not receiving an unconditional resignation from Mr. Zahn, it is my intention today to ask for his termination with cause. Mr. Zahn has only been an employee in the official capacity less than a year, and I refuse in good conscience to use ratepayers' dollars to pay him the full value of his contract, which we will hear that value today. I continue to say, I'm only one vote, but I strongly believe that the actions that I mentioned is critical and a termination with cause is justified and saves ratepayers' dollars. JEA will comply with any and all future investigations. And in light of yesterday's council meeting, each one of us should personally be embarrassed and know that our integrity is being tarnished. I personally am embarrassed. This has been I almost want to use foul language, but I won't. This has been a show. But this is not a personal decision. This is a responsible decision that we have to make here today. So with that, I would like to ask for a motion to terminate Mr. Zahn's employment agreement with cause. I would like to call for a motion to give notice of his termination with cause. Anyone would like to?
Madam Chair, can I ask a question?
Yes, sir.
Through the chair to the Office of General Counsel. I apologize, I have to give a opinion. Can you clarify what cause based on information would be?
It may be important. I skipped over our 3 presenters today because I wanted those facts to be shared with the entire board. I think our public speaking kind of threw me off there a little bit today. So can I get, John, we have you here at the table as our Human Resource Director, to give us the layout of Mr. Zahn's contract?
Yes, ma'am. With cause, or for cause, would be a reason to terminate. Obviously, without cause means he is entitled to the full benefits of the contract. And I'm here to discuss what those are and let you know what the dollar amount is. If he is terminated without cause, his employment contract calls for 20 weeks of pay of his salary, which equates to $200,150.80. It calls for COBRA payments for that term, which is for medical and dental for Mr. Zahn is $8,347.59. And that may vary a little bit on when the payments start. They should start January 1st, I believe. Pension vesting, actually there is no amount there because according to the GEDC, an employee must be employed upon complete 2 years of service, creditable service, to be 25% vested. So at this point, Mr. Zahn has not completed that service and would not receive any vesting. We are confirming that with the pension office, but it seems that he would receive nothing there. So the total based on his employment contract would be $208,498.39. In addition to the contract, if he is termed without cause, a separation and transition agreement applies, which would then be executed. It's referred to in the employment contract. And that, the dollar amount there guarantees him 12 months of a consulting fee based on his total compensation statement, which is greater than salary. That includes all benefits, pension payments. It's really complete compensation. And that would equate to $634,427.04. So the total, and that would be paid in monthly installments. It's a monthly consulting fee, so 12 installments of $52,868.92. The total, if both these agreements are applied for a termination without cause, is $842,925.43.
Any questions from the board for Mr. Kendrick? Ms. Flanagan?
Mr. Kendrick, the 30 days required notice, is that within your calculation of 842, or would that be in addition to amounts owed through to?
That would be in addition. This is upon termination, right?
So, Madam Chair, that's just in reference to the fact that
It could be in excess of 840.
That's true.
Where, can you clarify that? What question you're asking there?
There's a provision within the contract that provides for 30 days notice prior to termination. So the amounts that Mr. Kendrick referenced of 842 would kick in after the completion of those 30 days. So it would be an additional 30 days of comp, is my understanding.
That's correct.
Is that correct, or is it?
I'll defer to OGC, but I believe that's correct as we look at
The way I'm reading
contract.
it is payment will be made within 30 days. It does not say that's an additional 30 days.
Well, through the chair, the employment contract contemplates that if he's terminated without cause, there must be a 30 days notice given prior. So if the board were to take action today, I think all you could do is give notice of 30-day termination that would be effective 30 days from today.
Can you point to that in the contract, because that's not the way I understand it?
3.1.5 refers to the 30 days the payment must be made.
Yes, it refers
Yes.
to the 30 days of the payment, but it does not, it's not 30 days notice.
Well, in paragraph, in 3.1 under termination, it spells out the different ways the contract can be terminated, and under Roman numeral 4, it says by either party without cause or good reason upon 30 days advance notice.
Okay.
Madam Chair, I can agree with the termination. I just think that, and maybe this is just my pastor's heart, but.
Reverend, do you mind if we let the rest of our facts finders
Oh,
come
go
up
ahead.
and
I'm
speak,
sorry.
and then
Okay.
we'll go back to discussion on that. All right, if there's no further questions for,
Madam Chair, I did have a question, was just wanting you to clarify, or if anyone can clarify, we have a definition of cause, and has that cause taken place based off of the definition we have?
Okay, so the contract, if there's two avenues of termination that can be done by the board. One is with cause, one is without cause. And the contract does spell out specific instances of conduct that would constitute cause. And that's listed at paragraph 3.1.1. And there are six specific items listed.
That's page 4 of the contract.
Page 4. If your question is there evidence that any of these items have been violated? If there's evidence of cause at this point,
That's correct, that's my question.
I am not aware of all the facts. I think that it would need to be investigated. I think that I can tell you I've heard allegations. I heard the meeting yesterday. Certainly, there could be some of the conduct might rise to cause, but at this point, I can't tell you as I sit here today whether there's evidence of that. I can tell you that the cause provisions in this contract it's a high bar. They're very specific instances of conduct that rises to, it would require conduct that rises to gross negligence, which approaches willful misconduct. So it would be up to the board to decide whether there's evidence of that, and it may just require more investigation at this point.
If I may just add that certain provisions of this 3.1.1 also require notice, so please take note of that when you're reviewing it.
Well,
Certain.
only certain
Certain
points, I should say.
correct.
If the termination, so violations of JEA rules, company rules, directions from the board could rise to cause, but if it's a violation of a rule, it does require written notice from the board, and there's a 10-day period to cure. So, for example, I know there was a question of whether a secondary employment form was not filled out by Mr. Zahn. And so if that occurred and that was a technical violation of a company rule, that would require 10 days notice per the contract, and he would have an opportunity to cure. So that in and of itself couldn't constitute cause. However, there's other things that the contract specifies that could rise to cause. for example, and I'll read you, a pretty broad term employs gross negligence or gross neglect of duties and obligations or willful misconduct. So that's much broader, but it's pretty specific, willful misconduct. And that would need to be individually towards Mr. Zahn, evidence of willful misconduct by him.
Madam Chair, you mentioned 3 specific things that you felt like rose to cause. Can you go through those again? And then I would ask the Office of General Counsel to comment on those 3 individually and whether they rise to cause within the contract.
I personally felt like I was misled about the complete review by OGC of the performance plan. I was given no communication around the hiring of a previous board member's firm being contracted, and recently found out that the internal process to report the secondary employment was not done.
Okay. Can you speak to each of those 3 individually and how might, or if at all, they rise to the level of cause, as you said, was a very high bar within this contract?
Sure. If I could address the third, which I've already addressed, I think that a violation of the secondary employment in and of itself, he would be entitled to 10 days' notice and an opportunity to cure.
And I guess with that, what defines secondary employment? While I'm only know what I've read in the media about it, other than the letter that Aaron Zahn sent to us about it, my understanding is there was no compensation for that, so I'm not sure how that becomes employment.
My office has begun to look into that, but I don't have enough information at this
Right.
point to tell you,
Okay.
to answer your question.
It's
on that.
fair to say that an investigation has not been done.
No, it has not.
Right. But I guess further on that, if you own an LLC or a managing member of an LLC, which I know, I mean, for instance, you can be a member of an LLC and a managing member of an LLC, and it's not really employment if you're not receiving compensation for it.
I think it's going to be fact-specific as far as what constitutes employment, and we just haven't looked into it enough to be able to answer that.
And the reason I'm asking these questions is, and as a board member, I'm concerned about our risk, because I know as an employer in my day job, I know there's a significant amount of risk to the employer when you terminate someone for cause. And so I think that that's something that we have to look out for is this. So that's why I want to, it's a very serious issue, and just because emotionally we feel one way, or because the press is saying one thing, may not rise to that level from a legal standard. So that's my concern in asking these questions.
Right. Any other comment?
So that was the first one, or I guess the
Remaining 2.
can you?
So the other 2, as far as an allegation of misleading the board, I attended the hearing yesterday, and there were a lot of unanswered questions. There were a lot of documents that weren't produced yet. For me to answer that, certainly if there was intentional misleading of the board by Mr. Zahn, that would rise to cause. I can't tell you, as I sit here, that that's occurred with unanswered questions. I think board meetings would need to be reviewed. People would need to be questioned over exactly what did Mr. Zahn know and what was his involvement as far as that. So it certainly could rise to that, but again, it would
So
would
to
need to be
your knowledge
investigated.
today, it does not rise to that.
I don't have enough information to
So
answer.
no. Okay. And then what was the third one? Or did we cover them all?
No, we still have the disclosure of the firm.
Yes, disclosure of hiring the firm of a former board member.
Yeah, I'm not aware of any of the circumstances relating to that, so.
Well,
Oh, may I just add that the Office of General Counsel hires all special counsels for JEA, so including Milam Howard.
Right, and through the chair, if I could just add further on the specific contract of the board member that ran through the Office of General Counsel, and Ethics opined on that, and it was cleared. What the chairwoman is zooming in on is whether or not that information was shared to the board, but from a legal standpoint, that contract engagement was cleared and it was legal.
Does not sharing that information with the board, although irritating, and I would say I was irritated by it as well, not sharing that information with the board, does that rise to the level of cause under the contract?
It certainly could be willful misconduct.
Why?
Depending on the circumstances. If it's something that should have been shared with the board and wasn't,
But it was hired by the office of OGC, not by the CEO.
again,
Well, Mr. Brown, I think what we're doing now is you're trying to investigate at the table.
No, I'm asking questions. I'm trying to ask whether that rises to cause.
well, and you point out good questions that should be asked. I can't answer the question of whether it rises to cause or not. in
So
a
let me
vacuum.
ask, I guess, a different question. Can the CEO unilaterally hire an attorney without it going through OGC?
No.
And in this case, they did go through OGC and it was cleared through ethics.
Right,
So
so
let's
through
be
the
clear,
chair,
the
yeah, just to
concern,
clear, oh,
yeah, the
sorry.
concern is not that it was done properly. The concern is lack of communication and transparency
Okay.
to the board.
So, and then, okay, so then I'll ask it in a different way. Lack of communication on this matter to the board, does that rise to the level of cause under the contract? And again, I'm trying to protect the board and protect JEA in this because this is a very significant matter and it could cause significant legal risk to JEA if we get this wrong.
It certainly could rise. If it rises to willful misconduct, again, it would be fact-specific over what he knew, what he should have known, what exactly were the communications that were made to the board, all things that need to be looked into for me to give you an accurate answer.
And because I've only been on the board for a few months now, is the board typically notified of all outside counsel hired by the
Yeah,
by the firm?
through the chair, just to give you more information. So the board has a board policy manual that actually governs the relationship between the board and the CEO. And I'm not aware of any provision in that policy that would have required the CEO to report this information to the board, if that's helpful.
Yes, that's helpful. Thank you.
Through the chair, the only requirement I'm aware of is with respect to bond counsel. The CEO comes to the board of directors, but I'm not aware of one outside of bond counsel.
Right, correct. And the engagement with Howard was not
Was
bond
not,
counsel.
yes, correct.
Mr. Brown, you done?
Yes, for now.
For now.
If I may, Madam Chair, I believe that the initial line of questioning of OGC came on the heels of finalizing our understanding from HR what the financial and economic components of Mr. Zahn's current agreement entail. I would find it helpful if we could take a step back and hear from OGC on the spectrum of all of our viable options today, if that would be okay.
Yes.
Sure, through the chair. You could take action on the contract, and there's, if you wanted to terminate the contract, there's two ways. We discussed termination for cause, which would be effective today. You could terminate without cause, which requires a 30-day notice. So your action today would be to give Mr. Zahn notice of his termination without cause to be effective 30 days from now, in which case the benefits that Mr. Kendrick described would kick in. I want to let the board know I received a phone call from Mr. Zahn's attorney this morning. And Mr. Zahn, if it's the decision of the board to terminate him without cause today, Mr. Zahn has offered to amend his employment contract and reduce the consulting agreement from 12 months to 6 months. And with the rest of the contract terms remaining the same. His attorney is here today and can confirm that if that's the board's desire. Another option could be that the board not take action today in terminating the contract and investigate further. either by leaving Mr. Zahn in place, put him on administrative leave, and suspend his, relieve him of his duties for that to take place, if the board felt wanted more investigation done.
Madam Chair, so is it my understanding that he probably should have notified the board relative to secondary, but he didn't have to? Is that what I'm hearing? You said there was nothing in the contract or nothing?
Right, through the chair, the discussion that Board Member Brown, he was focused on the contract between, that JEA has engaged the prior board member, right? Was that correct, your understanding?
Right.
So that's different from the secondary employment. So my point with respect to the former board member's contract engagement through the Office of General Counsel was simply that that information is not required to be shared with the board.
Is that one of the points you brought up, Madam Chair?
I did, yes.
So my understanding then is that, again, he should have.
Well, that's.
I mean,
right,
I would
that's
think, let me just say,
correct,
I would
yes.
think that he should have, but he didn't have to.
Correct.
Okay.
The board may have preferred him to, but it wasn't in your policies that he was required to give you that information. And your policies, give the CEO sort of wide latitude to do the business of the company, the operations.
So I'd like to talk a little bit. Let's take emotion out of it. Let's take what I felt should have happened.
Okay.
Let's talk about the fact that Mr. Aaron Zahn has been in the newspaper and it has not been a positive story in the last 60 days. Let's talk about the fact that we are, every single board member here today, no one opposed that Aaron Zahn did not communicate fully when it came to the performance unit plan. I personally have received call from previous employees, previous board members, that there is more to this. We are talking about an investigation that needs to be had. So before, and we talk about risk to your point, Mr. Brown, we talk about risk. $842,000 plus is risk to JEA and every single ratepayer. What's the alternative? That we terminate with cause and then we investigate and we find out that there is no cause? Well, we got a couple of $100,000, whatever that number may be for the attorney fees that we may have to pay. But I think we have a responsibility to make sure that we investigate and ensure. We've apologized about where we should have asked questions. We should have looked a little more deeper. We should have pressed a little harder. This would just be another example of us allowing someone, our CEO, to come in, be here less than 2 years, that is his interim plus his employment, and walk away with taxpayers' dollars that, in my opinion, does not warrant. This would be a totally different conversation if we were having a conversation about someone that was employed, 6 years, 10 years, 12 years. But that's not the conversation that we're having. And in an abundance of $800,000+, that's a risk to JEA.
Madam Chair, if I will, I agree with most of what you said there, and I completely agree that we need to move forward with exiting Aaron Zahn from this organization. And my goal is that we can do that with certainty, that we can do it in a way that allows us all to move on. I completely agree it has been a distraction, and it's taken us away from the important work that all of the men and women of JEA and the entire city of Jacksonville are doing every day. It also takes me away from my job, and I know for everybody else at the table. So I am fully on board with us moving on. My desire is that we do it. I guess the part I disagree with there is the payment. While I will say I do not like it, and I do not like the fact that the contract is written in the way that it is. I wasn't here when we negotiated that. I wasn't party to drafting it, approving it, or anything. Unfortunately, we're left with those choices today, and I would argue that that payment is certainty as opposed to risk. The risk would be going forward with cause, terminating for convenience, is, or for without cause, and getting it behind us brings certainty to the situation, not uncertainty and further risk. However, as General Counsel brought up, there is an option. It sounds like there's an option to negotiate something. I don't know what that procedure would be or how we would go about that, but I think the most important thing is to not leave this open-ended. And my fear is if we terminate for cause and move forward with that, it will leave it open-ended. And my desire would be that we get this wrapped up, get it behind us, and get back to work. So I would like to hear more about what the options are for negotiating. If Mr. Zahn's attorney is here today, if there is a way to, we obviously can't unilaterally modify his contract because it is a contract between two parties. But if there is a way to negotiate some sort of exit that allows us all to move on, eliminates the risk, brings certainty to the situation, and does so in a way that is hopefully somewhat less, if not significantly less, than the severance and payout that is contemplated in the contract.
Madam Chair. I would like to know what is the dollar difference between the 12 months and the 6 month consulting?
Yes, sir, I just did the quick math. It knocks a little over $317,000 off, yielding a new total of everything between the contract and the separation and transition agreement of $525,711.91.
Thank you.
Before we move to that, I'm not sure if I'm comfortable with negotiating with Mr. Zahn's attorney here. But could OGC speak to the liability that lies? I understand that in the contract there is a mutual liability separation.
Right. Part of termination without cause contemplates that Mr. Zahn and JEA both enter into a mutual release of claims against each other. That would be required if there's a termination without cause.
I guess even with a termination, with cause, I guess it would not be a mutual release. However, his contract does have indemnification provisions for the time while he was employed and his actions while he was employed with JEA.
Indemnification for certain actions. There's a statute that governs what conduct would be indemnified and what conduct wouldn't. And things like intentional misconduct or intentional violations of law wouldn't be
Right.
indemnified, but certainly, yes, it does
Well,
include.
and I would hope that the release doesn't protect him from intentional violations of law either.
No, well, it releases him from all, I can turn to that.
I mean, I don't think we can, I don't think JEA can stand in and protect him from intentional or for him breaking the law. At least I hope not.
Through the chair, we're looking at section 4.6 in the employment contract, which is indemnification.
Thank you.
Well,
Yeah.
yeah, I was talking about on the mutual release, which is Exhibit A to the contract. It's page A2, paragraph 1.3. The general release by JEA, and it reads, JEA hereby releases and forever discharges service provider, which is Mr. Zahn, and each of his agents, representatives, attorneys, successors, from any claims that JEA may have or in the future may possess arising out of his employment relationship with and service as director, employee, officer, manager of JEA, and any event or circumstance or obligation that occurred or arose prior to the date that it's signed. However, it shall not apply to claims which cannot be released under applicable law. So it is a very, very broad release, and it applies to any claim that can be waived. It's not a violation of law.
Right.
Madam Chair. If anything, for me, I think it's become clear that in any scenario, we're moving forward without Mr. Zahn. 4 options have been identified by the Office of General Counsel as the legal mechanics for the way in which we move forward. I've heard various board members express certain rational concerns over the merits for and against each of these mechanics. But for me, the PUP, if anything, has been a cautionary tale in making a decision in the absence of complete information. And you raised concerns today that you felt as though there could be grounds for termination on the basis of cause. When asked, our representatives from OGC have indicated that they don't have enough information to conclude whether or not that is the case. I don't see an avenue outside of further investigation to get to the bottom of that question.
So are you recommending that we postpone, or?
I would recommend the option of administrative leave, suspension of duties, and investigation to determine whether or not cause is warranted.
I mean, that would definitely be up for discussion. I personally am not there. I am not, I'm not stating here today that I feel like Mr. Zahn should walk away with nothing, but I am adamant that rather it be almost $1 million or $500,000, that an investigation has not been done. And I believe if we, please help me with this, if we put him on administrative leave, we are only given 30 days to do that investigation.
No, that's not necessarily the case. That's not the case. We would certainly investigate as fast as we could.
So it could be indefinite. We would continue to pay him indefinite until the investigation is complete.
Or until the board decided to take different action, certainly.
Madam Chair, can I go back to my earlier question? And I know you mentioned you weren't really in favor of trying to negotiate, but just, again, I'll reiterate, I guess my personal desire would be to get this done so that we can move on. And I can appreciate Ms. Flanagan's desire to have further information. However, I think that is going to delay the pain and also continue to distract us from the work that needs to be done.
I do agree with that as well.
And again, I don't like the fact that this contract pays out that amount. I don't. So I guess I have 2 questions. One to you as the chair. Can you give us some, maybe it's 3 questions. One to you as the chair, can you give us some background on what the thinking was when this contract was negotiated and why this severance was put in place, and if there's any conversations or information you can share as to how this was arrived? So that's one. I guess second, kind of going back to my earlier question, is there potential for a process today for OGC to negotiate with Mr. Zahn's attorney, and if we tabled the matter to the end of the meeting, and if there was an opportunity to reach a mutually agreed exit where we could get this done today and move on? I think that was 2. I had a third, and I think I lost it in those. But I guess I'll leave it at those 2 questions.
The original contract was, the way it was described to me is that it was lumped in with every other employee. When Mr. Zahn was originally hired, he postponed us signing his agreement. He postponed us signing his agreement because he felt he wanted to be equal with all other employees in the performance unit plan. It was convenient that his contract was approved the same day, which was July 23rd, as the performance unit plan. But it was under the the auspice of all employees. And I would like to state that Mr. Zahn's contract is not the only one that reads this way. It is the same for our executive team as well, and that is something we will bring forward in the future to readdress. Your second question about negotiating. I'm not there because all I can think about is the liability. I believe that there is more there. And I believe an investigation needs to be done, and unless his attorney is prepared to take full liability for any future findings of allegations, that's where we would have to start. And then it would go on to the amount that he's asking for.
And
or
I
what-
guess
or
I
his
remember,
contract requires.
I remember my third follow-up question specifically to that. So really if we were sitting here talking about the 20-week severance as mentioned, that would be one question. And I think the real issue is this consulting agreement. I guess from a practical matter, is there a need for a consulting agreement? And if that wasn't there and we were talking about just the 20 weeks, would that change the conversation? And so maybe this is a question for management, but do they need Mr. Zahn to continue in a consulting arrangement? Does that provide any necessary value to the organization?
So go ahead.
To my understanding, the problem would be we can't change his contract now.
Correct, but his attorney is here, and I'm sure they, within the next few hours, could diligently try to figure something out in an effort to get this behind us. And then I guess going back to the practical matter, and maybe this is a question that we would need to ask management of, do they need him in a consulting capacity?
OGC, I have to ask you, if we, to continue to negotiate, could we continue to negotiate if a motion is made and approved to terminate with cause to follow negotiation? I mean, is there a way to terminate and then, well, if we do it with cause, then there's nothing.
If he's terminated with cause, that would be effective today,
Right.
and he would be terminated. Florida law limits severance pay in a contractual situation to 20 weeks. And so it's the maximum in this contract. Mr. Zahn's contract contemplates additional compensation over that in the form of a consulting agreement, so that's a separate piece from the severance pay.
Right, and that was my question around that. I mean, it is, coming from the private sector looking at it, that's different. And I think it's looking at them separately of the severance. And again, I think if we were only talking about severance, it would probably be a lot easier conversation as opposed to this consulting agreement. And so my recommendation would be to try to negotiate down or away the severance agreement and get this behind us. I mean, I'm sorry, the consulting agreement. My recommendation would be to try to negotiate, reduce, or eliminate the consulting agreement in order to get this done and behind us.
Go ahead.
And Mr. Zahn, through his attorney, has offered to reduce it to 6 months. I don't know if I mentioned the consulting agreement also does contain a provision that it can be terminated for cause. So if cause is discovered during the consultation period, that agreement can be terminated.
Would that go back retroactively to claw back payments that were made during that consulting period?
I believe, the way I read the contract, yes.
So it could. So if at some point in the future it was determined that his consulting agreement is terminated for cause, that amount could be clawed back.
Oh, no, I don't think it could be clawed back. I
It would
think
just end at that point.
It would be ended at that point. I'd have to do some further research to see if we could claw back but I don't want to answer that question right now.
So as, again, going back to my experience in the private sector, I would take that offer from the attorney as a first offer. I can't imagine that, that anyone would expect that to be a final offer.
And did it include that they would take liability?
No, it was no other changes to the employment contract other than reducing it. I just relayed the message to you. I think you're right that the way negotiations work is you don't usually start with your best offer, but I haven't had any other negotiations with him.
Mr. Brown, I'm willing to do that. If Mr. Zahn's attorney is willing to come to the table and discuss and allow us to discuss some options, we can do that. Mr. Peak? Come on.
Morning.
Hello, Jake Peak. I represent Aaron Zahn in this matter. Thank you. Aaron was asked if he would accept 6 months instead of 12 months, and he said that to bring resolution to this, he'd be willing to. We were not asked to come here to negotiate today, so just haven't prepared for that.
Yeah.
So I don't have the authority, nor did we imagine that that would be a topic to address today. Again, he was asked if 6 months would be acceptable, and he said that would be.
How would you see a potential negotiation moving forward if that was possible? I mean, how, like, what, and I guess this is a question both for the chair and for OGC of how could we move forward with this? It's so that we're not left with the simple binary solution that's in the contract of cause or without cause. Because that's, it just, we're handcuffed in one camp or the other that are, you know, what was the number, $800,000+ apart. And that just, as a board member, as a, you know, representative of the community on JEA, does not put us in a good position. We have to find something in the middle.
Mr. Peak, if we took a recess, would you be able to contact Mr. Zahn and get authorization to negotiate?
I could try to contact Mr. Zahn. Again, I didn't come here today prepared for negotiation, so I don't know how that would play out.
Well, and through the chair, through the chair.
Go ahead.
Really quick to Mr. Brown's question, I think as attorneys, what we're going to need is a clear parameters as to, you know, what your negotiation points are, right? And so today, if the charge is to go off and negotiate a different agreement than what's currently existing, you've got to give us some clear guidance on that, sort of the highest, maybe
Okay, so I have a question. How do we do that and it be public record? And then if we give you the highest, then obviously that's the highest they're going to go for. That seems like an impossible task.
you're a public entity, so you can't discuss unless you're in a public meeting. And the other thing I would get you to think about is if you charge us to go off and negotiate, obviously if we reach an impasse, the existing agreement is still in existence and he's still the CEO, so
Correct.
think about that.
So at this point, there is an agreement of 6 months on the consulting. We're not talking about the 20 weeks. We're talking about the consulting.
What was the 20
12
weeks?
months.
12 months. I'm
12.
sorry, what did I say? I'm sorry.
Yes,
Consulting.
it's reducing
so-
the 12 months to 6 months.
Right, so the lawyers come back with 6 months. That has already been agreed on with Aaron.
Aaron was asked that if he was terminated without cause today, would he be willing to accept an amendment to the consulting agreement to 6 months instead of 12 months? He said yes, that if he was terminated today without cause, he would be willing to amend the consulting agreement to 6 months.
Which includes a release of liability if,
All of the terms of the,
Right.
all other terms of the contract would remain the same.
Madam Chair, just a quick question. What advantage do we get for terminating him with cause?
we don't pay or $500,000, and we can continue to investigate and find out to clarify all of the allegations that have been put out there.
But we still hold the liability of litigation if, I'm not saying anything, but if he were to pursue it, we'd hold that liability as well.
Right, and if it comes back that there is no cause, then we are held to the contract anyway.
Madam Chair, perhaps OGC could walk us through the provisions that exist in the contract with respect to any dispute over termination for cause.
That would be great.
So if Mr. Zahn is terminated for cause, in the contract, he has the right to challenge that, and that would be through an arbitration process, where we would agree on an arbitrator who would serve as judge and jury, and it would be an adversarial hearing where evidence would be produced. It would be JEA's burden to prove there was cause. Mr. Zahn would defend himself, and it would be up to an arbitrator to decide whether the evidence presented meets the definition in the contract of cause. If the JEA was successful in that arbitration, the case would be over without owing Mr. Zahn anything. If Mr. Zahn won the arbitration, then JEA would owe Mr. Zahn what he was entitled to, as if he were terminated without cause.
Do we incur legal fees to go through this process as well?
So the contract says each party is to pay its own legal fees, although it's likely if Mr. Zahn was successful, there would be interest added.
Would
That's
he have the
typical.
opportunity to bring other actions such as defamation?
Defamation, no. But perhaps there's all, when someone's terminated from a job, there's a litany of claims that could be made for wrongful termination. I can advise you, in this case, I feel very strongly that he doesn't have a claim for any violation of law for this termination.
For
If
wrongful.
that's what you decide.
He does not have a claim for violation of wrongful termination.
I don't see that, given the facts and the issues that this board is contemplating.
But then also what you said earlier, based on your knowledge today, of what you know today, you do not believe that it rises to cause under the contract, based on
Because-
what you know today.
Because an investigation has not been yet done.
Because I've heard allegations and I don't have facts to tell you that
Right.
this is what I would walk in and prove.
There's been lots of allegations for several months on lots of things, but unfortunately not a lot of facts. So based on the facts you know today, it does not rise to the level of cause.
Based on the limited facts that I know, correct.
Mr. Brown, do you have anything else you'd like to add?
No, I will just reiterate that I think I still think there's an opportunity to negotiate this and get this done today, and get it done for far less than the $800,000+, and get it behind us.
Mr. Pica said that he didn't come prepared to do that today.
I'm sure he is a very competent attorney, and it would not take much preparation for him to speak with his client and engage in that.
I asked that question directly.
Oh, and I really don't understand the procedure of how that would work. I'm not trying to be difficult or
Right.
very open,
No,
being amenable.
I think if we are open to it and you are able to reach out to your client and get some negotiation parameters, is that something that you would want to do, you think would be a good course of action today?
I'd like to understand what that is, and maybe the Office of General Counsel could help, again, how that happens under the sunshine laws, how that happens in a board meeting.
Right,
I
I
don't
would like some
understand.
direction on that as well, because it's
So,
Madam Chair, I think that we have to make a decision if it's about the consulting contract. He's already agreed to 6 months. We have to make a decision if we're going to negotiate, what is the bar? I mean, we can't just send him out and say, call him. I mean, what is it that we can agree on as it relates to the consulting contract?
Correct.
Reverend Newbell, I don't disagree with you, and I'm going to use an old adage that my grandmother used to use. If it walks like a duck, quacks like a duck, it might be a duck.
I understand that.
And with that being said, we don't know what else is out there. We don't know what else. And yes, I understand that everything that's been said today have been nothing but allegations. But we have not been given the opportunity to do the investigation. And I think that we have to be responsible to do that before we agree today that we're going to release. I'm not saying that we can't negotiate what that number should be, rather it be the 6 months or the 12 months of the consulting, but it's the liability that sticks me. It's the liability, as Councilman Beckton stated. Just letting him walk away, the community still wants answers. They want to know what has been done with ratepayers' dollars. So I am willing to negotiate. The only thing that and I'm one vote, I'll say that again, as I continue to say, is that the liability must lie with Mr. Zahn.
And if he, again, if he committed a crime, if he did something illegal, he's not releasing that, correct? I mean, that changes everything. And so if any investigation by city council, by whoever else, I mean, JEA is not, we can't release him from that. I mean,
Correct.
So I think that's important. I mean, we're not giving him a pardon for the rest of his
We're
life.
not, but we're giving the community answers.
And
That's-
I think that is outside of the scope of our board. I think it is up to us to get back to running and doing the important work of JEA.
I agree. That's why
And
I agree with you not to move forward. Absolutely.
So that's why I'm just going to reiterate it. Anything we can do to get this done today. I guess I would recommend that we eliminate the consulting contract altogether and use that as a negotiating point and instruct Mr. Zahn's attorney to take that back to him and go forward with his severance under the contract, eliminate the consulting agreement. I'm not an attorney, so the release agreement, I'm not exactly sure what additional we're releasing that we haven't already indemnified him for his actions while he was CEO. We obviously can't release him for anything that he does in the future. And once he is no longer CEO, he is on his own. So I think that's another reason it's important for us to get this behind us and get him off of our payroll and allow him to be a public citizen and face what he faces as that. So I guess with that, it is my recommendation. And again, I think because it would be an additional distraction, we probably don't want him as a consultant during the following 12 months. So I don't know exactly how we do this, but it would be my recommendation that we negotiate a modification of his employment agreement to eliminate the consulting agreement from his from the termination, and everything else essentially remain as is. And then once that is removed from the contract, then terminate him without cause and move forward.
So through the chair, that's a motion, that is motion, correct? So what we could do is, if you offer that as a motion, the board could approve that motion, by a majority sitting here. We could recess the meeting. We could then confer with this attorney that's right here, and maybe he could reach Mr. Zahn to see if that's amiable. Is that possible?
I can certainly try to reach Mr. Zahn. Having not spoken with Mr. Zahn, just my immediate response and thought as an attorney is that's a large architectural change to the agreement, and I would need to think through all the implications of that. It's much simpler to say I'm going to change 12 to 6 than it is to say we're going to eliminate a large body of the agreement and what other impacts does that have on the rest of the agreement. It's a more involved question legally that would take time to think through. It may raise ancillary issues.
And that's a good point. So maybe I will propose that we modify the consulting agreement to 1 month for him to help with the transition.
And again, I'd ask what the parameters
So
are.
that sounds like the exact same thing, just with a shorter time period.
Understood.
And so kind of to your point of not modifying an entire structure or body of the agreement.
That's responsible.
It's exactly the same as 6 months, it's just less time.
I agree.
Okay.
On the contractual architectural aspect of that.
So not to put you on the spot, I asked the question, would you be willing to do that? And you stated that you were not prepared to do that today. So just to negotiate. So before we back you into a corner, and it sounds like you want to have time to consult with your client, as well as do your legal findings as well. Then that would lead us back to Board Member Flanagan's recommendation, which is to possibly put him on administrative leave until those details could work out.
Madam Chair, just a point of reference. We said that the issue at hand is the amount we're going to be paying out, but it sounds like if we go the administrative leave route, we're going to be paying out more money.
Well, it all depends on how quickly we negotiate.
I guess I would propose, and I don't, you can help me on how we actually structure this motion, but I would propose a motion that we attempt to negotiate a revised agreement reducing the consulting from 12 months to 1 month, and instruct Mr. Zahn's attorney to present that offer to him and give him a very short time period to respond while we either recess or move on to other business, and then table the discussion until we have that response from Mr. Zahn's attorney.
I'll second the motion.
Madam Chair, can I make a quick assessment? I'm not knowing the backbone of why we create this agreement. My fear is that we run a extreme risk legally, and I want that to be referenced on the record, if we go down the option of doing it with cause, if OGC is giving us a direction that, based on the current facts today, it's just a fear of mine, but serve it to the board.
I appreciate that, but I will reiterate yet again that an investigation has not been done. So today's opinion is based on the words that the OGC used today, limited knowledge that they have today. So I want to go on record to say that as well. So we had a motion. We had a second by Reverend Newbill. Any discussion regarding the motion on the table?
Through the chair, because this was a new agenda item that was placed on the table, I just want to, it's your prerogative, you could open this up for public comment.
Thank you. Once again, we're going to start moving forward with the issuance of transparency. And so being that we just noticed that we would be taking up the CEO's contract yesterday, if there are any public comments, I will actually take a recess of about 2 minutes for those that need to take a convenience break, and also to allow the public, if anyone would like to make any comments. So let's recess for about 2 minutes and give those that want to make a comment the opportunity.
Have to slightly toe out.
Could be allowed. There was a change to the COBRA agreement. I mean, the number it was figured at 2019, right? So it goes up about $600.
Okay.
If that's material.
All righty. I may call you. Let's wait for Kelly.
Oh.
We'll wait for Board Member Flanagan, and then we'll get started.
Probably didn't say that again. I said you probably didn't say that again.
Oh, she didn't hear me?
I don't think you did.
Get their attention for me, please. Okay, before we move on to public comments, we did amend the agenda today to add 3 speakers. We've heard from John Kendrick as well as OGC. Can we please have Ms. Willett come up?
Madam Chair, if it's in order, I want to recognize our former mayor, John Delaney, in the audience.
Yes, most definitely. Thank you for attending. It's good to see you. So I've asked Ms. Willett to give us the investigation that was started on the recent ethic allegations. If you would do that for us, please.
Absolutely. Good morning. I'll introduce myself since we have a new board member. My name is Willette Stanford, and I currently serve as JEA's Ethics Officer. It is an appointed position by the board, which I was appointed back in 2011. I report into Ted Hobson, who's the Chief Compliance Officer here at JEA, and I've been here 16 years. So I prepared a statement just to make sure I had all the facts, as you asked. JEA employees will comply with the City of Jacksonville's Chapter 602 Ethics Code. JEA has a secondary employment policy to implement this code. As the ethics officer for JEA, it is my responsibility for maintenance and implementation of this policy and for providing guidance. All employees receive mandatory training on this policy annually. Aaron Zahn took his training on April 30th of 2019. Secondary employment includes operating a business or any outside work. Employees are encouraged to inquire if they are uncertain as to the applicability of this policy to their particular circumstances. JEA has no record of any secondary disclosure for Aaron Zahn. A disclosure should have been filed, however, I've done no formal investigation, just some preliminary research. And I did confer with the Office of General Counsel and the City Ethics Officer as well.
Thank you. Quick question. What is normal practice of who it's, before you begin your investigation of who and to follow an allegation did you report to before starting your investigation?
Typically, when I start an investigation, I will refer to my Chief Compliance Officer, my boss, or I'll just start it on my own, depending on who it is. Because it was a CEO, I did go to my boss to get authorization in terms of should I begin an investigation or not. However, if it would have been an employee at a lower level, I would have immediately started an investigation.
So you wouldn't have gone to Carla Miller, who is the city's ethic officer?
Yes, I would definitely confer with Carla Miller as well.
But we didn't do that in your initial investigation.
My initial, I did not.
Okay. I just wanted to also mention and have you confer that I actually called right after I read the article in the newspaper about the possible conflict. And I asked you a simple question, and that was, how was the LLC that Mr. Zahn is being associated with, how was that contract procured? And you told me that you were told not to investigate. Can you go a little further up as to why you were told that you could not investigate this particular allegation?
At the time, I was asked to not investigate, but to wait, and then later on, I was given permission to look into it.
Do you know why you were told to wait?
Not sure, and I did not ask.
Okay. Any other questions from board members?
Madam Chair, we have a motion and a second on the table. Can we go through the vote for that?
Well, I think the recommendation from OGC was to pause to take public comment. I just wanted to back up because we did do an amendment to the agenda, okay, and to make sure that we had that information before we took the vote.
Thank you.
I do have a question. You were told not to investigate initially. You were told, who told you not to investigate?
My boss.
And who was that again?
Ted Hobson.
Okay.
But again, it could have been, we have a partnership with the Office of General Counsel and also with OIG. So if it's dealing with waste, fraud, or theft, they do the investigation. So very well, we normally look to see what needs to be done. That's why I asked the question. So he may have done research because at the time he was in Atlanta, so he was not here for me to speak to.
And can you help us understand what would define outside work or outside business? And I guess it's just my understanding in this case this was a passive investment or an outside investment, a non-income producing investment.
Well, preliminary research showed that on his financial disclosure form, he listed a business as secondary income. So that's what I looked at, because it was listed as secondary income. Income would drive to be in secondary employment because there would be some type of income coming. And again, that would be something that I would sit down and confer with the employee to come to that determination.
And you're saying it did, in the financial disclosure, did list this as secondary
It did,
income?
yes.
Okay. And that financial disclosure,
It's filed by the state.
Right.
As CEO, he would have to file, and he
And so
filed
that-
it in June of this year.
and so he did include it on his financial
Correct, he
disclosure?
did. He did.
Okay, I think that's
To the
different.
state.
To the state, yes.
Yes. Which JEA and you would have received a copy of?
No,
or-
the state gets that. I don't get a copy of that
Okay.
document. I asked for it, but I would not normally get a copy of that.
But it was
filing.
disclosed on that?
Yes, it was.
Okay, thank you.
According to Mr. Zahn's contract, is he required to disclose that to JEA?
His contract states, I believe, he's not allowed to have any type of business.
Could we
but-
read that? Could we find that in the contract and read that specifically?
Well, through the chair, I think actually the contract allows him, so if you would turn to page 2, 1.4, diligence to position, employee shall devote full business time, energy, and best efforts to the business of the employer with the dedication in the manner of similarly situated executives. But if you go down to the sentence that starts, subject to, the foregoing, employee may not engage directly or indirectly in any other business, investment, or activity that interferes with employee's performance of his duties, is directly contrary to JEA's interests, or requires any significant portion of employees' business time. So really what that's getting at in the contract is outside business is allowed as long as it doesn't interfere. But notwithstanding this contract provision, there's a charter provision specifically as it relates to the managing director and CEO that says you cannot have an outside business or secondary employment. So one is a contract restriction that's more lenient, I would say, and then the other is the charter restriction that is more restrictive. And from an OGC standpoint, I know we've had conversations with Ms. Stanford about what is secondary employment. Jason Gabriel has opined. We've even had discussions with the ethics office that a mere ownership in land is not something that would equate to secondary employment. You might also have ownership of land being held in LLCs, entities of that type. But the analysis was the minute you start adding additional facts, so you're selling your property, you're holding yourself out as a business, then that could, as a secondary employment, maybe equate to being as such. On the restriction related to the managing director and CEO not having outside business, as Sean stated, I think that's something internally we need to look into further. We just don't have enough facts, our office, we don't have enough facts to make that determination. Does that help?
Somewhat, yes. Yeah. So, but just ownership of outside land does not count as outside work or an outside business?
Mere.
Even if it was held in an LLC?
Right, if you're just holding land, you're doing no other activity, mere ownership. The minute you add additional facts onto that, the analysis, the outcome would change. And I think that's the extent of the opinion that our
Or
office is giving.
would change or could change depending on the facts?
So for example, if you have an LLC that's holding land, you're putting signs out, hey, I want to cut up the parcels for development, obviously that you would be engaging in the activity of a normal developer. So I think that's the way, and again, it's fact intensive and we just haven't done the research or investigation to know what all the facts are.
Quick question, just clarification. It was filed on the state disclosure as additional income.
Correct.
Okay. Income meaning revenue. Income meaning receiving payments.
Secondary sources of income.
Secondary sources of income. So that is more than just mere land ownership. Okay.
Madam Chair, if you don't mind, I do have a clarification question, because we've been talking about secondary income or secondary employment. what is actually being questioned? And that's for OGC. Like what, the actual issues with secondary income?
So my explanation was as to secondary employment. And that's
Okay.
the restriction that's in the charter. That's also the restriction that's mentioned in the contract.
Okay, and what was filled out incorrectly is secondary income.
It's a secondary employment policy, which is under the city charter called moonlighting. So it's just, if you're producing some type of income, then more than likely some type of employment or something is either a business or something is driving that income. So that's how we define it here at JEA as secondary employment.
Okay, but based off of the example that you gave, there are scenarios where you can have ownership of land or an LLC and receive income from that, which would say you're in violation, or there's a additional form you would need to disclose in the secondary income category.
Correct.
So my next question is what's the typical response if there's a failure to, like, you didn't fill out the secondary form? What's the typical response there?
It can vary. We would ask them to complete one, and typically, if I'm not sure, the employee's not sure, most of them will just go ahead and complete one, just to have it on the record. But based on the policy, just like in any of our policies, employee can be disciplined up to including termination, depending on the level of the violation. If there was a conflict of interest, maybe they were doing that work here at JEA at the same time they're working at JEA, so it goes to various levels. And it just depends.
But traditionally, if the form is acknowledged that there's secondary income and a form wasn't filled out, the applicant, the individual filling out the form would be asked to fill out the form.
Correct. And it would be routed to their boss, and then their boss would approve it, and then myself as the ethics officer, I approve it as well.
So I guess a follow-up from that, was Aaron asked to fill out the form?
No, Aaron was not asked to fill out the form. We discussed this, but at no time, I didn't have enough information to really get to that determination at the time Aaron and I were discussing. Okay. But again, in his contract, I think what I heard earlier, he would have 10 days to resolve that issue. So if it did come to that, then yes, he would be given time to fill out a form. But at this time, no form.
Thank you.
You say there are different scenarios in the questions, to follow up to Ms. Johnson's questioning. Even if the form was completed, isn't there a violation if that particular entity that they have ownership in is doing business with JEA while you are employed?
Yes, it would. That'd be a conflict of interest, and that's why we have the form filled out, to avoid and be aware, JEA aware of any type of potential conflict of interest.
Okay. Reverend Newbell, you have any comments from Mr. White? Board Member Camille? Thank you so much.
You're welcome.
All right. Any other questions for Mr. Kendricks before I relieve him from the table?
Madam Chair, I just want to update one figure. We, when we figured the COBRA payment, we used 2019 rates. We should use 2020 rates. That was when it was kicked in, so it would increase the COBRA payment by $892.79. The new COBRA figure would be $92.40.38. Thank you.
Thank you for that.
Chair, question. Are you speaking about is that with the 12 months or 6 months? I mean, what are you?
That's just part of the employment contract that he would receive COBRA payments for medical and dental.
Oh, okay.
Yes, sir.
Okay. Alicia Grant? Right up here, please. If you could limit your comments to about 3 minutes, and state your name.
Alicia Grant, 9976 Ridgefield Drive, Jacksonville. I come as a retired CPA, a retired certified internal auditor, and a retired certified fraud examiner. And I can tell you that during the discussion over the last couple of months, my red flags and my radar has just been zinging because of all of the disclosures that are going on. at the very least, or at the very most, I should say, and I put my card down there, I checked as opposing, but I support this termination. And I support terminating without cause effective today. That will limit our liability to the 20 weeks of COBRA, no pension investment without investiture, which I just thought was ridiculous for somebody who has only served for 8 months or less than 8 months. If you choose to terminate without clause today, that doesn't preclude you from continuing to investigate everything that has gone on. It limits the liability to the 200 and the COBRA 9,000 something. And I don't think any of this other contract should be expanded to include any kind of consulting. Why would anybody want him on board as a consultant, given what has transpired over the last few months? The other thing is, I don't think we should accept any liability, period. I'm just taken aback by the length of discussion and how much we want to protect him when he really deserves no protection. The man has no integrity. He has no consciousness about what he has done. And the damage that he has done to this municipality, to this agency, to the trust of the citizens of this organization. And I know that there's Councilman Carlucci is going to be introducing an ordinance for a investigation, grand jury investigation. And I think given what you may find in a continuing investigation and if you discover something with cause, you can terminate as 20 weeks at that point, and take it back to termination with cause. So I just think that's the easy way to do it today and move on and let the grand jury investigation, if it happens, find out what's behind this. Thank you.
Thank you so much. Reverend Anthony?
Good morning again. A business decision should not cause for crucifixion. Mr. Zahn may be crucified, but the truth will resurrect him. What I rise to say this morning is that people get up every morning to go to work. In our country, we're turning people that are good citizens and making them into criminals. And that shouldn't happen. People make mistakes every day. I'm reminded that when Jesus himself healed a man on the Sabbath day, all of the leaders and everybody else sought to crucify him because he healed a man on the Sabbath day, which they considered was work. And that's what we're doing here today. Where is grace and mercy coming into people that get up every day to go to work? Not to be criminals. You got drug dealers that get up every day to go on the corner to sell drugs that need to be put in jail. Not this man. He gets up to go to work every day. How would you like for somebody, just because you made a mistake and you get up to go to work? And let me just, because my mind is just going crazy right now. If I own some land that my parents left me and I become CEO of JEA and I do the right thing, I sell my mother's property because I don't want anything to do with it because I'm working at JEA. Is that considered work? Are we serious? I mean, we got to look at things a little bit different than what we're looking at things today. And I'm taking my point from the Bible. Jesus did no work on the Sabbath day because he healed a man that needed, if the man was about to die, he healed the man. What's the problem? This man got up to go to work every day. These are not common criminals. Politicians. People are not common criminals that get up to serve the community and to serve us. because they made a mistake, I say to you today is look at it differently. If a man makes a mistake, does he deserve a crucifixion? No. Jesus even gave, when he was on the cross, he told him, the thief that was on the cross, that was a criminal. He said, I'll remember you, because he asked. Let's don't do this to him, please.
Thank you. James Taylor?
Good morning. As a longtime resident and a ratepayer since 1965, I would like to speak to you guys. We've heard already this limited conversation that there is more to investigate. And I support Chairman Green's idea of put them on admin pay, continue the investigation, because when you start uncovering this, peeling this onion, you're going to find more. And to compare Mr. Zahn with Jesus Christ is blasphemy, and I don't care who that offends. It offends me. I mean, we're talking two different things, and it's not one item. He's done more and more and more. And this land deal was also a partner with somebody that JEA hired to be a lobbyist. Now, if that's not a conflict of interest, I mean, Ray Charles could see this. It's getting crazy. And I sat here and I know you're a new member, Mr. Henry, or Henry Brown. You've danced around this elephant for the last 2 hours. It is what it is. This man is a crook, he is immoral, and he has ruined the reputation of this company that's been here 125 years, and he's only been here 2. I mean, it's ridiculous. It's ridiculous. So I urge you guys to keep continuing to investigate and find out what's going on. And I understand you're in a hurry to get this done. Put him on admin pay. Make it a limit, 3 months of investigation, something like that. Because I understand you're trying to cut the liability. But we can't let this man keep robbing the citizens of Jacksonville like he's been doing. Thank you.
Thank you. Andy Johnson?
Good afternoon. I'm Andy Johnson, 13581 Breaksea Court, Jacksonville, 32224. For 35 years, I've been proud that JEA was our utility. I felt a personal association with JEA. I was in the legislature a long time ago. I helped the JEA on everything they needed. And then for the last 35 years, most of the time as a radio talk show host, I've been a defender of the JEA and all of our independent authorities as important parts of our city government. An important part of our charter provides that each JEA board member is supposed to be chosen by the mayor for overlapping staggered terms. This mayor chose to violate the charter, chose to do an illegal thing, chose to eliminate the staggered terms, and that's why we've had the problems with the JEA. We could see it coming. And that's why we're having the problems with the Children's Commission. We could have seen it coming. Now, I think the only right thing to do is we need to fire Mr. Zahn with cause. Tell him to get out the door today and don't pay him any more money after today. In fact, look for ways to recapture some of what you have paid. And then also, I think that the JEA board members need to think seriously about what they've done. I think all JEA board members who voted to choose Zahn and also all JEA board members who voted for the bonus plan, that may include all board members, maybe it heads up to everybody. All those board members need to resign right now, today, and then the mayor should choose for new board members only people who have served on the board sometime in the past as a way that we try to clean up our mess. I don't trust the board, I don't trust the executive director, I don't trust anything about JEA right now. And that's a sad thing to say about an institution where I've been closely associated all these years. If we could have a new, fresh start here in Jacksonville where we decide we will comply with the charter in the future and we'll only choose board members that serve staggered terms, then that would be a good way to go. But the mayor set in motion the inevitable squalor and scandal and disgusting mess by choosing to eliminate the charter provision and choosing to run roughshod over the charter. JEA can be a great utility again, but right now it's an embarrassment. the people who are a step down from Mr. Zahn, the ones who are not chosen by Zahn, are good people, but anybody who's been chosen by Zahn to be here needs to go. I feel angry about it. I'm fed up with it. Most of Jacksonville's angry. Most of Jacksonville can't get to JEA board meetings. I can't normally come down here. I felt I had to come today. Thank you very much.
Thank you so much. Last comment, Councilman Matt Carlucci.
Thank you, Madam Green, Chairman Green, Chairperson Green. My name is Matt Carlucci. I preside at 1532 Alexandria Place, South, Jacksonville 32207, lifetime resident of Jacksonville. I just could not come over and speak. I didn't want to, but I decided to. And I'm backing up your chair. Now, I don't know all the nuances behind a contract, but I know what's happened to the JEA. It's a public utility, which is why I think a grand jury is in order, because a grand jury is made up of the public. I know every one of you love this city, and I applaud you for your service. And none of us are perfect. I get it. But I just have to tell you that if nothing else, you must let Mr. Zahn go with cause. Sometimes we hit bumps in the road. I've hit bumps in the road myself. And sometimes you have to make tough decisions on people that you know. But you know you have a fiduciary duty to the citizens of our community. I haven't been here to hear all your discussions and all of this and that and the other. I was a member of the Florida Commission on Ethics for 5 years, and I do know that there was one ethics violation that in all likelihood would bring probable cause, and that's the property ownership. But I know one thing: we need a new start. We need to find the very best, and Jacksonville deserves the best public utilities CEO that can be found in the United States. That person might even be here in this room, I don't know. But we need to find the best, and we need to get on with being the best public utility we know to be. The headwinds are not that strong. I've done my homework, lots of it. And the headwinds can be met, and there are markets available. But we got to put this behind us. So we're going to investigate this for 45 days. I'd rather see the grand jury take care of that. Y'all hire the best CEO, do the best job you can as board members, and let's get the JEA back on track. And that way, the folks of the Jacksonville City Council can get back to devoting our full time to our citizens. I'm at 000, so I know that my time is up. Under the very difficult situation, I wish you a Merry Christmas, and thank you for the time, Madam Chairman.
Thank you.
Chairperson.
Through the chair, Ms. Rohde has brought a fact to the attention that I think the board should have before it votes on this motion. So there is one other contract that I believe, Ms. Rohde, you've confirmed Mr. Zahn has signed, and that's a retention agreement. And that's the agreement that all of the employees signed, and pursuant to a recapitalization event, then all of the employees would get 3 installments, basically, of their salary at the time. And so the reason why we wanted to bring this to your attention, because the motion on the table is to terminate without cause with the 1-month consulting agreement, all the other rights and benefits remain the same, is that if there's an involuntary termination under this agreement, and involuntary termination is defined as a termination of the employee's employment by any member of the JEA group, which would include JEA, any of its successors, without cause, then that could also trigger a right to receive additional funding under this agreement. So we wanted to make sure you had that information. So in other words, if you vote for a termination without cause, if there's a recapitalization agreement, Mr. Zahn may stand to also receive additional monies under this retention agreement.
Madam
Just
Chair.
wanted to give you that information.
For clarity, is that in place for every employee that works at the organization?
Through the chair, I believe so.
And that's a separate agreement that he signed individually?
Yes.
Correct.
Madam Chair, we may want to ask Mr. Kendrick to confirm that. He actually brought that appropriately to my attention.
Thank you, and also talk a little to the value of that retention if we have to pursue it.
Yes, ma'am. The retention agreement was put in place for all employees and collectively bargained with our unions in the event of recapitalization to keep employees here, given the uncertainty of the nature of the possibility of the event. So it guarantees 100% of salary as of July 23rd of this year, paid in 3 installments, one upon the date of recapitalization, 1/3, another third 1 year later, another third 2 years later. And the intent, as I understand it, was that if someone was involuntarily terminated upon recapitalization, in other words, if a new company came in and someone lost their job as a result of that, that is what I understand that provision was there for. But the language, as OGC said, apparently just says if someone is terminated without cause, the provisions of that agreement could kick in.
Correct. So the language says, notwithstanding, if the employee ceases to be employed with any member of the JEA group, so again, JEA group includes JEA, during a retention period due to an involuntary termination, the employee shall be eligible to receive the entire amount of the retention payment to the extent unpaid, and the payment installments shall vest on the applicable vesting date. So we interpret that, there was a consensus here, you have 3 OGC lawyers, that certainly if there was a recap event, then this contractual provision would be triggered.
So, Madam Chair, I just want to make, again, point of clarity. So any employee that's been here at the JEA that's involuntarily terminated falls into this provision?
Only if recapitalization happens.
Only if yes. That's, okay.
And that's
Right,
even if they're terminated before the recapitalization event?
Yes.
Right, correct.
Okay.
Correct.
Madam Chair, I would like to amend my previous motion to also include elimination of the retention agreement.
And Madam Chair, that motion is still on the table at this time.
Okay, so, and we also
No.
had a second.
There has not been a
Does he
second to
need
the
a-
amendment.
He just
The
amended
amended.
it.
Yeah.
Does he need a second?
Yes, sir.
I second.
Alrighty, any discussion?
If I may, through the chair, just wanted to ask one follow-up question of OGC as it relates to the consulting agreement can be terminated for cause. Does that cause have to occur during the consulting agreement, or if there is something that is subsequently discovered that relates to before today, is that cause also applicable for termination of the consulting agreement?
Through the chair, the agreement isn't specific. It just says the consulting agreement can be terminated for cause, and it uses the same definition. It refers back to the employment agreement for the definition of cause. And my reading at this time of that contract is that it doesn't have to be cause that occurs after the termination. Of course, it could be argued the other way.
Ms. Johnson?
No questions.
Mr. Gray?
No question.
Madam Chair, just as it relates to my motion, I want to reiterate that I am not trying to defend any action of Aaron Zahn, and I'm not trying to minimize the impact that these actions have had on the city and have had on this organization. And I want to, I guess, reiterate what Councilman Carlucci said, that there's a lot of things that should be investigated. I just don't believe it's the duty of this body to do that investigating. And I hope that things are investigated, and I hope for everyone that nothing is found and everybody's able to move on. But that's outside of this scope. My desire with the motion that I have on the table today is to allow JEA and this board to move forward with the important business of JEA, and then let others do their job with the investigation and move forward in whatever means is necessary in that regard. I would like to I'm trying to get this behind us in what I feel provides the lowest risk to JEA and the lowest risk to the taxpayers, and to bring forth an amount of certainty to this and an ending to this for JEA. What happens from there is outside of our scope.
Thank you.
Thank
you. I agree, Mr. Brown, that it's to investigate is not in our preview. I do agree with that. Where I disagree is that we have the responsibility to protect the ratepayers. Now we have just added an additional possible $500,000 with the retention plus, with the retention plan, if it is not negotiated to be removed. And we to this day, we don't know if Mr. Zahn would accept that.
Correct.
So I'm not there. I am still there. The more we talk, the more we learn. So I will ask if there are any other discussions around the motion that's on the table.
Madam Chair, I might recommend that the motion be restated for clarity since there was a recess.
Okay, great.
Yes. Ms. Rhodey, can you restate the motion to your interpretation of it?
I believe, please correct me if I'm wrong, I believe that the motion on the table that was subsequently amended and seconded is to move forward with a termination without cause with continued negotiations and an outstanding issue as to the consulting agreement, which is Exhibit B to Mr. Zahn's employment agreement.
To move forward with a maximum of 1 month of consulting.
Maximum of 1 month consulting and removing his eligibility for the retention agreement.
All in favor signify by saying aye.
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 Those opposed, do the same. Aye. And I believe we had 1, 2, 3, was that 4?
5, yes.
5. So the motion moves.
So through the chair, I just want to be clear, Mr. Brown, you had referenced possibly taking those terms back, or no? Or how is the board? I just want to make sure. So
my understanding was moving forward with a termination without cause and instructing Office of General Counsel to negotiate directly with Mr. Zahn's attorney to accept a revised employment agreement, which would have a maximum of 1 month of the consulting contract, reducing the consulting from 12 months to 1 month. And then the amendment was to eliminate the, forgot exactly what it's called, the retention agreement.
Correct. I thought I had heard some desire to try to do this today and take a recess. Yes. Is that your?
To recess or to table
Because
it
where
to
do we
the
go
end.
from there?
Yeah, to table it to the end of the meeting. And I think if we're not able to reach that agreement today, then maybe there's the potential for a different motion at the end of the meeting.
Okay, so the direction is to
Do
negotiate.
that.
Is that possible?
Yes. Yes. Yeah.
Okay, right there.
Madam Chair, would you prefer recess or to table? What is, are we?
Gosh, I would hate to put a timeline on them. Maybe 20 minutes? Sure. All righty. Let's recess for about 20 minutes. All right, I'll open with Mr. Brand from OGC to tell us where we go from here.
Right. I had a conversation with Mr. Peak, Mr. Zahn's attorney. He expressed that Mr. Zahn is willing to negotiate further, but not today. Mr. Zahn's attorney isn't familiar, hasn't seen the retention agreement that we've discussed, and wants a chance to review that. So they indicated that there could be some further negotiations. So earlier you asked what the board's options are, and if the chair would like, I have another recommended option.
Please do.
Another option the board could take is to place Mr. Zahn on administrative leave. You could suspend him of his duties today and ask the OGC to begin an investigation while at the same time continuing negotiations with Mr. Zahn. If he would, and then further, if Mr. Zahn would agree to the parameters that the board set, meaning he agrees to amend his employment contract to a 1-month consultation term rather than the 12 months, and if he would also agree to forego entitlement to the retention agreement that's based on recapitalization, then the chair, if those things happen and we reach that agreement and his contract was amended, that the chair is authorized to sign that amended employment agreement or whatever process is required, and further that the chair would be authorized to give Mr. Zahn the required notice of termination without cause and start and put into effect his termination without cause to occur 30 days after the notice is given. And the board could give the chair authorization to do that without further board action.
To the chair, I have a question on that. Could we begin that notice today so that it doesn't extend it any further than it has to, even if we're still negotiating these terms?
Well, the problem with that, if you give notice, then the termination takes effect in 30 days under the current agreement.
Okay, I understand.
And that's not a good negotiating
Okay,
position to be in.
I understand.
Another question. Can we continue to investigate during the negotiation period so that if cause is found, then we could come back to the board?
Absolutely.
Do you recommend putting a time limit on the
Yes.
negotiation?
Yes, I believe you mentioned that.
Potentially even sooner than the next currently scheduled board meeting?
I agree, absolutely. Any other comments before, anyone else have any comments regarding the recommendation from OGC?
Madam Chair, you may want to clarify what that period would be as part of the recommendation.
So right now, we're saying to put Mr. Zahn on administrative leave, suspending him of his duties, OGC to continue to negotiate, to negotiate the defined parameters that have been set here today, which are that we will terminate without cause, correct me? Terminate without cause with 1 month of the consultation agreement, and to remove the retention agreement.
Right. You're
Okay.
you're authorizing us to negotiate an amendment to his current employment contract. And if he agrees to that and we execute an amended employment contract, you would also then provide immediate notice of termination without cause,
Giving him the additional 30 days.
giving him 30 days
Is it
notice.
possible to, is a 30-day period enough time to negotiate, you believe?
The negotiations would take, as long as.
Based on their response?
Based on their response, I'm not sure how long they would take.
And a question on this, that 30 days, so would he just remain suspended on administrative leave during that 30 days?
Yeah, while they continue to negotiate and investigate.
Well, I mean, even after, so once the negotiation is finished, you give him notice of the 30 days. During that 30 days.
He would remain.
He remains on leave, suspended with no duty.
Yes, we probably need to be specific in that. If that motion is.
Not to throw another wrinkle in this, but the 30 days required notice is part of the contract, and so that could be renegotiated too. If you wanted to make that part of your offer of amending the contract.
I would suggest that it be immediate.
Okay.
immediately on,
Termination, not giving the
On-
additional
Right.
30 days.
so the termination without cause would be effective upon amendment of the employment contract.
Right.
Okay.
Are we comfortable with 30 days to a deadline as a time period to negotiate? Any opposed of that? That would get us before the next board meeting?
I would, so that would be before the next board meeting? I guess that would be my concern, is to make sure
I
that
don't
it was
know what that
finished
date
before
is.
the next board meeting.
January 28th, so yes.
I think they mentioned that.
I would almost make it shorter. I don't, I mean,
I
it
feel
seems
like-
like, it seems like it's pretty
I'm-
simple.
I'm fine with that as well. I kind of wanted to take OGC's lead on that.
I don't think the negotiations, I mean, it's known what your offer
Right.
is.
Yeah.
So we don't have room to negotiate further without coming back to the board, so I don't know that it would take that long. Now, if the OGC is charged with investigating, that, I don't know how long that would take.
I think 2 weeks.
So we'll reduce the 2 weeks?
Yeah.
Does everyone agree with 2 weeks?
I could even go to 1 week.
was
I
thinking
think
a
it's going to
week
be one of
was
those things.
sufficient,
that's-
Given they have all the information.
Yeah, I don't know that it'll take that long.
Welcome aboard.
Well,
Okay, so we'll leave it to 7 days,
Well,
7 business days.
okay, and next week, there's 2 city holidays, just so you're aware, the 24th and 25th.
25th.
So I count 7 business days from today. Would be Monday, December 30th. Do you get that? Monday, December 30th.
Okay, Lynn, we need to do a motion for that.
So I believe what's being discussed is that Mr. Zahn would be placed on paid administrative leave for 7 days until December 30th, during which time OGC is directed to negotiate with Mr. Zahn an amendment to his employment contract, including a termination without cause that would become effective immediately upon the amendment to the contract, a reduced consulting period to 1 month, and agreement that he is ineligible for any retention, for the retention agreement. I believe that's what's been discussed, and is that correct?
Correct. Did you mention the charge to investigate? I'm not sure I heard that.
Charge to
The charge
OGC
to
also
investigate
during
and-
this period to move forward with investigation.
Correct. And then the last element that we need is just authorization for the chair to execute all of those documents that flow from this motion, the amended employment agreement, the mutual release, as well as the 1-month consulting
And the notice of termination.
and the notice of termination.
Could you clarify again what the chair will need to provide authorization for?
So the chair would need authorization to sign any and all documents to affect this motion, which would be including but not limited to the employment, the amended employment agreement, the mutual release, the 1-month consulting agreement, and the notice directing the termination without cause.
So itemizing the documents. Yeah.
And I guess further clarification on that, you said suspended on administrative leave during this negotiation. Should that not be suspended indefinitely? Because even if the negotiations are not fruitful, we would want him to remain suspended through the next board meeting, at which point we would take some other action. Would that be correct? I mean, we don't, if the negotiations don't work out, we don't really want him coming back in 7 days to
I
his
agree.
job. So it should be
So
suspended,
indefinitely.
suspended
It's up to the board.
indefinitely.
Okay.
The negotiations just last.
Good point.
Okay, so what's being discussed is that Mr. Zahn will be placed on paid administrative leave indefinitely. OGC is directed over the next 7-day period until December 30th to negotiate an amended employment agreement with Mr. Zahn, including termination without cause that would be effective immediately upon amendment, a 1-month consulting arrangement and ineligibility for the retention agreement. In addition, OGC is directed to move forward with an investigation, and OGC and the acting JEA management would be authorized to execute any and all documents to effect that motion.
Through the chair, Ms. Rhodey, I think it's the chair, not OGC, that we're
right.
authorizing to execute.
To work with.
Does that make sense? To
The chair
literally
is
sign the
authorized to
contract, it
execute?
would need to be the chair.
Is that your understanding, Madam Chair?
Yes.
Okay.
They will negotiate
Okay.
based on the terms laid out today.
And just to be clear, if the terms are accepted, the board today is authorizing the chair to carry that out, consummate, what's contemplated in this meeting and execute those documents that flow from the motion that's been stated.
And it's the
But for
board's.
the, I'm sorry, but for the record, not to change the parameters that are discussed here today.
Absolutely.
Okay,
Absolutely.
And to make it clear that if the employment contract is amended as is being offered by the JEA board today, that it's the board's desire to proceed with termination without cause, which would be executed by the chair.
Yes. Okay, so we need a motion?
Yes. So-
we need a new one?
Well, I think Lynn's
luck repeating all
articulated
that.
it.
Would you like me to repeat that again?
Yes, please.
Okay. So the discussion, which we do not yet have a motion on, is that Mr. Zahn be placed on paid administrative leave indefinitely, excuse me, over the next 7 days. OGC, excuse me, is directed to negotiate an amended employment contract with Mr. Zahn with the following changes. He would be terminated without cause effective immediately upon the amendment. The consulting agreement would be reduced to 1-month period, and he would be ineligible for the retention agreement. OGC also would be directed to move forward with an investigation, and the chair would be given the authorization to execute any and all documents to effectuate that motion.
I move, move the motion.
Second.
We have a motion and a second. Any discussion?
Madam Chair, do we have clarity and understanding of what would occur should something be discovered during that investigation in the 7-day period?
So the chair is authorized only to execute that amended agreement after 7 days if it's reached. During that time, if something comes up, Mr. Granite, I believe the board could reconvene. Is that correct?
Or could we authorize to move forward with cause if something comes up?
I think you'd want separate board action to terminate with cause. If OGC comes across evidence that we believe supports cause, we could individually notify the board members and perhaps a special meeting could be called, or think of anything else. We could authorize the chair to not give the chair discretion.
Yeah, I think you're going to need a special meeting to make that decision.
Yeah, I'm comfortable. I think we should come back to the board with any type of, if something is found through the investigation, that we come back to the board to discuss what the next options and what those terms should be due to cause. Yeah. So do we need to include that in the motion, that if we do not reach a negotiation or if something is found in the investigation, that we will move to a second meeting, a special meeting?
Well, I mean, it's through the chair's prerogative to call a special meeting. We'll keep you informed. We'll provide you, Sean, will keep you appropriately informed, and you can poll your members and call a special meeting at any time. I don't think you need to include that in your motion.
Okay.
Also, don't forget the public comment. It's a new motion that's on the table. Once you're done discussing.
Okay. Are we comfortable with coming back to discuss if something is found through the investigation? I'd like to hear.
If negotiation is not completed and fully executed and something else is found, then absolutely. if there's something that rises to the level of cost.
I agree, Madam Chair.
Okay.
And I would note also for the chair that what Mr. Granite pointed out, that cause also is triggered under the consulting agreement, even if that's for 1 month.
Yes.
Right.
Right. Ms. Johnson?
No.
Mr. Gray? Okay. All righty, if there's no further discussion, we have a motion and a second. All in favor indicate.
Do you want to open that up for comment?
You love those public comments.
Just trying to keep you.
It's a new motion on the floor. So we have a new motion on the floor. If they have any public comments now, so that we don't have to take another recess, just kind of put your hand in the air if you'd like to say. Take this opportunity to take 3 minutes to speak. Okay, no public comments. All in favor of the motion, if you'd like to repeat the motion one last time.
Sure. There's a motion that has been seconded. It is to place Mr. Zahn on paid administrative leave indefinitely over the course of the next 7 business days until December 30th. OGC is directed to negotiate with Mr. Zahn an amendment to his employment contract with the following changes. He would be terminated without cause effective immediately upon the amendment. The consulting agreement would be reduced to 1 month, but otherwise remain intact. And he would not be eligible for the retention agreement. The chair would be authorized to sign any and all documents to effectuate this motion. I believe that's what's on the table.
Okay, all in favor signify by saying aye.
Aye.
Those opposed, please do the same. So I think that was everybody, unanimous?
Yes, ma'am.
Motion passes. All right, let's move on.
So, the interim.
Well, gotta get back to my agenda. The next order of business is that we need to continue to do business at JEA, and so we need to ensure that we have someone that is capable of continuing to keep the operations going. And so I would like Ms. Dykes to come up, Melissa Dykes to come up. I would like to call for a motion that we have Ms. Melissa Dykes as the interim to assume the duties of the CEO, duties and responsibilities, until we pursue further action on the CEO replacement.
I move the motion.
Second.
Any discussion? All in favor, say aye.
I'm so sorry.
Here she goes.
Yeah, it's a new motion. I'm so sorry. Can you open that up?
Sure.
before
Any
you-
public discussion regarding the new motion on the table to accept Ms. Melissa Dykes as the interim CEO? We've got one comment.
Board members, I'm against this motion. Ms. Dykes deserves better than this. She gets jerked around, she gets kicked around. We put Zahn in ahead of her, and then she should have had the job to start with. I think you all ought to quit pussyfooting around, quit this dilly-dally. I think you ought to just name her as your permanent director right now today and no fooling around about it. That's what I think.
Thank you for your comments. Are there any further comments? All in favor? I'm sorry.
I would like to take up that question.
Yes, sir.
What options do we have outside of interim? Is there a possibility that we could name Melissa as the permanent CEO, or do we? Or is there a process in place that we have to go through?
So through the chair, if I could defer that, I know there was a lengthy process that occurred the last time. Could the chair, the director of HR give us some insight, just to give the board some information, how traditionally this has been done? Certainly the board in your charter, you're absolutely empowered To appoint a managing director and CEO, they have to meet certain qualifications. Clearly, Ms. Dykes would meet those, but can you just share with the board some information on processes y'all have done in the past?
Unfortunately, I wasn't here when the process was done. I know it was an exhaustive search. A search firm was hired. I'm not sure about how the process was implemented. I'm not sure what the charter calls for, so I'd have to do some research. Melissa, even though it puts her in a difficult position, may have some insight there, but I'm sorry I don't. I'll be happy to investigate it.
I will open it up to further discussion, Reverend Newbells, but it's my opinion that we take our time. I think everybody believes and knows Mrs. Dykes' ability. That is definitely not in question. It is without hesitation that we ask her to come and step in yet again to help us out. And I have to say that my conversation with Ms. Dyke was commendable because her first concern was the employees of this organization. So I know that she's the right person for the interim, but I also think that we need to, as I said, not move hastily and make sure that we do a thorough search and make sure that we have the right person that can go forward. And that right person may be Ms. Dykes. But we need to make sure that we're thorough and we take our time. That's my opinion. Anyone else would like to weigh in?
Yeah, Madam Chair, I agree that we need to take our time, and I agree that for now should be an interim. I would hope that we hold off on a search and give Melissa the opportunity to earn the permanent job. And I think if we have the opportunity to allow someone to move up from within, I think that would be the best thing for the organization and for our city. And I think doing a national search of an outsider who has not been part of Jacksonville, not been part of this conversation, I don't know is necessary. And my hope is that she will earn the permanent job, but I think starting as interim is probably the prudent step.
Thank you for that.
Madam Chair, I remove the question.
Ms.
I
Johnson?
echo the same sentiment.
Madam Chair, just for procedural purposes, I think, I don't know because I haven't been here long enough, but I think we have some process things that we need to fix in terms of our agreement. Based on what the general consensus has been today and the fact that we've been here for 3 hours discussing a contract, I do believe that we should also take into consideration the agreements we have in place.
Absolutely, I agree. One of our first things we should pursue, not just with the executive director, but all agreements, employment agreements. Ms. Flanagan?
I echo the board's sentiment in support of Ms. Dykes. I agree that we should be diligent in not making a hasty decision, but I hope that Melissa voices interest in staying with us for the long term in this role.
Alrighty. If there's no further comments, all in favor of the motion to have Ms. Melissa Dykes as the interim CEO, please indicate by saying aye.
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 We did
I did know.
What happened?
We wanted more public comment. Let's do that one more time.
No one raised their hand, that's what happened. You asked
Yeah,
for it.
we did. We allowed him.
Oh, yeah.
We only had one.
Yes, ma'am, you did.
We did.
Public comment.
Okay. Let's try that one more time. All in favor of Melissa Dykes as our interim CEO, please indicate by saying aye.
Aye.
Those opposed, please indicate by doing the same. The motion passes unanimously. Ms. Dykes, I'd ask you if you would like to say a few words.
Thank you. I am humbled that the board has put their trust in me for this interim period to lead this organization. It's clear from the conversation today and the conversation over the past few weeks that we have work to do to restore trust with the community. And out of the gate, that'll be my first priority, is to work with members of the board to craft a plan to restore that trust, both by changing how we do business at JEA and changing how we communicate with the community. That will be really important. In addition to that, I think it's going to be important for us to work collaboratively with board members, obviously individually, and then later in board meetings to make sure that we have a common set of priorities and goals through this interim period. And I hope to begin that work immediately after this meeting. In the meantime, though, it's incredibly important that our employees continue to focus on the things that are most important to our community. It's incredibly important that they continue to work safely every day, that they focus on making sure that each and every employee goes home safely at the end of every workday. And that we focus on continuing to support them in the great work that they do, delivering operational excellence and high-value service to our community. Our employees do great work in spite of whatever noise is going on around us, and they should continue to be supported in that work through this transitional period. So thank you again for placing your trust in me, and I will do my best to make you proud.
Thank you, Ms. Beggs. Thank you. Alrighty. Let's move on to the consent agenda. I would like to call for a motion to accept the consent agenda with an amendment to add Melissa Dykes as the interim in the annual disclosures in place of Mr. Aaron Zahn.
Madam Chair, I believe the annual disclosure approval is a separate
It is a
item
separate
on
item.
on the
I tried to
agenda.
get it all in there, you guys. Alrighty, so let's, can I call for a motion to accept the consent agenda as
moved.
is?
So moved, Madam Chair.
Second.
Any discussion? All in favor indicate by saying aye.
Aye.
Those opposed, do the same. Motion moves. Alrighty, annual disclosure. Can
That
I-
is item 3B.
Correct. Item 3B, Mr. Wanamaker?
Good afternoon. I've asked Joe Orfano to come up with me for this presentation. Joe and his Treasury team coordinate the preparation of the annual disclosure report each year. And we wanted to walk the board through some of the key points of our disclosure policy and the process that we go through to prepare the ADR each year.
Thank you, Ryan. Thank you. JEA's disclosure commitment is as follows, and I would like to read this because it's very important. JEA is committed to ensuring that its disclosures made in connection with its municipal bond offerings and required periodic filings, such as the annual disclosure reports, are fair, accurate, and comply with applicable federal and state securities laws, including anti-fraud provisions under state law and any other applicable laws. Next slide. What are we doing to keep course with SEC expectations? A few underlying tenets to our disclosure are as follows: be intentional and systematic. And how do we do that? We develop and maintain sound written policies and procedures, including our disclosure policies and procedures. We look at things from an investor's perspective. We want to tell the credit story and identify the, quote, elephants in the room. And finally, we keep the disclosure free from politics. An overview of the annual disclosure report preparation is as follows. With the assistance of finance staff, I am primarily responsible for the preparation of the annual disclosure reports, ADRs, for the electric and water and sewer systems, and water and sewer also includes DES, District Energy System. We get assistance from bond counsel. We've recently retained Greenberg Traurig as both bond and disclosure counsel. And the Office of General Counsel, Ms. Rohde in particular, and other JEA staff with specific subject matter expertise. Named members of the SLT senior leadership team, 8 individuals review and sign off on the ADRs before they are sent to the board for approval. And a total of at least 45 JEA staff and outside individuals have input into and review of the ADRs. And I would particularly like to provide a shout out to Robert Hahn, my Treasury colleague, who shepherds this process every year. Thank you.
Thanks, Joe. So this is an action item today to approve the 2019 annual disclosure reports for the year ended September 30th, 2019. A draft of the ADR was provided to board members in November, and myself and Joe were available for one-on-one meetings over the past month to address any board member questions or concerns. In your package today, you have a complete set of both documents, as well as the red line pages from the first draft that we distributed to board members last month. Furthermore, JEA's disclosure policies it require that I provide board members with documentation of compliance with our disclosure policies in the prior 12-month period. Accordingly, that documentation is provided in this board item as well. All disclosure reports and disclosure documents prepared in the prior 12-month period were prepared in accordance with the disclosure policies, and no issues or problems have arisen in connection with compliance with the disclosure policies during the prior 12-month period. So we're asking for board action today to approve and authorize the release of the annual disclosure reports for both the electric and water systems, as well as to authorize the interim managing director and CEO in consultation with OGC and bond counsel to make additional corrective and clarifying changes as necessary. I will flag, as you noted, Chairperson Green, that the board, one of those additional changes we'll have to make is to reflect the personnel changes that took place this morning.
Thank you. I know everyone's had an opportunity to review the disclosures. Or any questions for Mr. Wanamaker? Alrighty. Can I get a motion to approve the annual disclosures with the administrative changes, specifically to Melissa Dykes as the interim CEO? Are there any other changes that we need to make?
I don't believe so at this time, but the board meeting's not over.
Madam Chair, I move the motion.
We have a motion on the floor.
Second.
Any further discussion? All in favor indicate by saying aye.
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 Those opposed do the same.
Aye.
That's 5-1. Motion approved.
Thank you.
We have left here. All right, I see the end.
You're on to the original 3D. I'm sorry, 4D, the original 4D.
So the next item is original, based on the amendment, the original 4D, the discussion of the mayor's recommendation regarding the ITM process and JEA's future. In discussion with the council president, we have decided to defer this conversation until the next board meeting. In light of the negotiations, the continued negotiations that we will have going on with our leadership change, it is my recommendation to support that request from City Council. Any further discussion before?
Madam Chair?
Yes.
For clarity purposes, Vice Chair made a statement in the beginning that it is this City Council that's ultimately going to make the decision. Is that correct?
Correct.
Is there an advantage that we get by deferring it to next month?
It's just that we have so much on our plate, we need to get our house in order, is the simplest way to say that, as well as working in conjunction with City Council to allow them to do their work, and they're not going to reconvene on anything but this matter until after the first of the year per council president.
But wouldn't that take some of the work off our plate by giving it to a body that has additional infrastructure to go dive deeper and become more transparent? Because as it stands right now, isn't that what the issue is, that it's not transparent?
I agree, but it also gives us the opportunity to dive deeper as well, to make sure that what we present to City Council that ultimately could possibly go to the ratepayers is the best that we can offer.
Madam Chair, I have a question on that. So if we defer it, does that mean that it is business as usual for the ITN process and strategic planning
Correct.
process?
Yes.
So we're still in the same situation as we are now with not being transparent to or what's being perceived as not being transparent?
So what happens is the ITM process will continue. It's my understanding, I'm trying to think who can help me understand, Lynn, can help me understand that the ITM process will bring us to the end of January where they will actually be able to compile. I believe the last
Madam
option.
Chair, just to clarify, I think that the schedule would be part of a negotiation that the negotiation team is undertaking. So I believe that the ITN would proceed as
In its current form?
authorized under 2019-07, and it is currently in the negotiation phase. So currently, under that ITN, that negotiation phase would continue, and that would be at the discretion of the negotiation team.
So to Mr. Gray's point, it would still be under the cone of silence, and so it would still not have the transparency that's needed.
That we desperately need.
Would that be correct?
There are restrictions, what's called the cone of silence, on communications during the negotiation phase, and that would continue until the negotiation, until that cone of silence lifts.
Madam Chair, from a practical standpoint, with the leadership changes that we've addressed today, is there a possibility of suspending the current ITN process until the new leadership has time to evaluate and until City Council, as you said, they will not be taking it up for some time, until we have further direction from City Council and potentially the mayor's office?
So I would go back to the reason why the ITN press, the intent of the ITN, and that is that we can continue to kick the can down the road. The issues still lie there in terms of a decision needs to be made about the future of JEA.
Well, and I understand that.
But that's just my opinion, so I would definitely like to open that up.
Yeah,
for discussion.
I guess my proposal or recommendation would be to continue the strategic planning process and continue the evaluation of all the options that were put on the table, and maybe even additional options if the new leadership determines there are additional options, and continue the strategic planning process while potentially suspending the ITN process to let them finish strategic planning and then have a better path forward from there, a better idea of what the ITN really being an outcome of strategic planning rather than strategic planning itself.
It is one of the options of the strategic planning, correct?
That's correct.
Correct. It's one of the options presented in the strategic plan. I guess I would think, just given the leadership changes, given the lack of transparency that Mr. Gray mentioned, that it might make sense that with this leadership change that we take a break on the ITN while we finish our full analysis of all the strategic planning options. And once we finish those options and are able to present those fully to the public, then we are able to make a determination of whether to restart the ITN or pick up where we left off. I don't know exactly how that would happen or how that would work, but just from a practical standpoint, it would seem prudent to do that.
Madam Chair, a quick question. Isn't it, or I'm sorry if I don't say this eloquently, but didn't we keep our current COO to in the interim capacity to keep continuity?
Yes.
So if we are positioning to keep continuity, and of the public and of what I've heard, and I've constantly talked to people, transparency is lacking significantly. So my question is, if we have continuity, because we have an interim, why would we not go through the process as it stands and make it transparent to the general public?
To move forward with the mayor's recommendation.
Yeah. If it is the recommendation of the body to make it transparent, which is what I'm believing it, turning over to City Council makes it transparent.
So I'm going to open it up because I would love to hear what the rest of the board members have to say. But I would also like for us to take into consideration that our bondholders, as well as the credit rating agencies, are watching this process. So a lot of our decisions can be and will be affected by those things. And so by slowing the process down, that's still leaving uncertainty out even beyond our community. But I would like to open it up for comments from the board.
Thank you, Madam Chair. I would like to engage in a thoughtful discussion on this topic, but it would be helpful for me to frame that discussion with a legal perspective of what avenues are available to us before we get too far in terms of debating the merits of any hypothetical situations.
Being where we are in the process, what are our legal ramifications of
In-
pausing?
Right, in terms of pausing, in terms of modifying,
Yeah.
in terms of,
Good question.
Yep, Madam Chair, our Procurement Counsel, Robert Jose, is in the audience. If he is amenable, come up and answer some questions, particularly with respect to how the decision here today, whatever it is, will impact that process in the context of the existing ITN.
Madam Chair, glad to address any particular questions. So you're in the middle of the process. It probably makes sense to step back to understand why you're doing an ITN, right? Or why you went down this path, is to understand what the market has to offer so you can make better decisions. A lot of time, energy has been invested in this process. So you're, let's say you're halfway through the process, give or take, whatever. Certainly pausing the process would potentially endanger the process of finishing the process. You're close to being able to, conclude that process and provide the city council, the mayor, the public that information, right? Of what does this really look like? It's one option, as you all acknowledged earlier, and that would allow you to compare that option to the other options.
What are the implications of pausing?
Certainly, you've got people you got the respondents that are involved in this process, so certainly they have a lot of time and energy invested in the process as well, so it certainly impacts the competition potentially. Certainly, they may have rights, right, as under the process to certainly pursue.
You just said rights to pursue. What do you mean?
Well, in any government procurement, a rejection of all bids, right, is essentially what you would be dealing with. In that scenario, right, they may try to pursue those rights. We've reserved rights to protect JEA, but these respondents, they're significant companies that have invested a lot in this process. So, I cannot tell you, what they may want to do, but certainly they may want to, look at their options.
Can I ask it, are those risks any greater if we pause today or if we suspend indefinitely the process without releasing the cone of silence, just basically suspend it temporarily? Are those risks any greater to do that than if we get to the end of the process? Because I think, as it is said by this board, this is just one option that we're looking at, and we, as a board, may determine that it's one of 4 other options, or, it's really an unlimited number of options that we could go down as a board. And this is just, I think it's said that the ITN process is there to produce information to support the strategic planning process. So in that case, is it really a procurement process in the first place? Or is it really just an information gathering process? Because it seems like it's being spoken as both. And I'm a little bit confused because I wasn't here when we started this process.
Agreed.
And so is it a procurement process or is this an information gathering process? I think that's important for us to answer.
Yeah, certainly it's a procurement, it's a process intended as it's currently moving forward to present a best value determination to this board as it currently exists. Obviously, the mayor's letter is relevant to that question. I think the risk, I think, is the base of your question. Essentially, it's the integrity of this process, right? It's been a process that's been protected by the cone of silence that is pursuant to Florida law. There's a reason for the cone of silence, is to protect the integrity of the process, to protect or prevent any undue influence, outside influence, corruption, et cetera. So, regarding transparency, the JEA has been completely transparent that it's going through this process, and there's a period of time that there are negotiations, just like there have to be negotiations that are protected so that you maximize the amount of competition you get, right? So you protect that process, prevent the outside corruption, risk of corruption, et cetera. So pause it, you just elongate the process.
Madam Chair, through the chair, I hear you, but the people of Jacksonville, as we've seen in public comment, don't feel that way. So
Perception's important, understood.
very important. So my question then is, if this is an actual bid process, how do we make it transparent?
Bid processes are certainly transparent to the taxpayers, right? That's government procurement is designed to protect the taxpayer, right? The process that the JEA is going through follows that process. So it may be that the general public doesn't understand that there are protections for them. There are certainly things in place that the conversations, the meetings that take place during this process, they're preserved. They're just temporarily exempt from public record and public meeting, right? So all of that information is available to the public at the right time pursuant to state law.
Yes.
Madam Chair, my understanding was that this was one of the options that was being explored. I never.
The ITN.
The ITN. Yeah, I never understood it as being bidded out some way, or if you win, if you get the approval, then you're going to be the company, and we're definitely going to do that.
I don't believe that's what you're saying today.
What?
It is not. So what would be presented under the current process is here's a determination of best value, right? That is ultimately determined and voted on by you. That is sent to obviously the city council. The city council is able to review that, and ultimately a referendum for the community is necessary as well. All of that is transparent and included in the current ITM process.
Okay. So then what happens to the other options?
Right.
All of the options are presented, not just the ITN bidders.
I believe
Yeah.
So just to clarify, the recommendation that would come from the negotiation team as a result of the ITN process would be one of the options on the table that the board would consider.
Okay.
If the board determined that that ITN recommendation was one it wanted to move forward with, it would then vote on that recommendation and send it to city council.
Madam Chair, going back to my previous question, because I don't know that it was answered, do we have more risk in suspending the ITN process today versus letting it play out and then ultimately canceling it if we decide to go in a different direction?
I believe there is more risk to suspend the ITN.
Can you expand on that?
It's
and what would that
primarily
be?
the integrity of the process.
And what risk does that bring to JEA?
From
And why does it reduce the integrity of the process? I mean, it is my understanding that government agencies decide to suspend or cancel procurement processes all the time.
That is correct. Yeah. So are you suspending? Is that the question? If you suspend, so it's you elongate the process, potentially question, put question or doubt into the process, et cetera. Right. So
I think there's already doubt into the process. I think that's pretty clear from a lot of reports.
My question, but we have 5 options, so we theoretically don't have to go through with the ITN. Is that correct?
Well, ultimately, I don't believe the city council has to elect to move forward with the option under the ITN or the community via the referendum, a necessary referendum as well.
Are we at risk with any of that?
I'm not sure I understand that question.
If they choose not to go with the ITN, are we at risk?
No.
Let's talk about timeline. So when we're talking about pausing, where in the, if you can, because I understand that we are still under the cone of silence, where are we in the process? What is the turnaround for the ITN results to be revealed?
Right. So the negotiation team has a lot of discretion to negotiate, and so that that can be done quickly. That can take a long time. So you're, as Ms. Rode spoke, you're in the negotiation phase. Those negotiations could conclude in theoretically in a week, a matter of weeks, or a matter of months. I know that the team has been working very diligently to conclude as quickly as possible.
Is it realistic that we could ask that those negotiations be completed by January 28th?
I believe so.
I'm sorry, what's January 28th?
That's our next board meeting.
Okay, sorry.
Any further question around
It's,
this? Go ahead.
I'm sorry. And Madam Chair, and maybe this may be a question that someone from management, maybe our new interim CEO would need to answer, but the question would be, does management have enough information to present the outcome of the strategic planning process with a reasonable estimate of what an ITN would produce, even if it's not with certainty, where they could complete the process without knowing the outcome of the ITN process?
Ms. Dykes, would you like to come up, please?
The simple answer to the question is yes for scenarios 1, 2, 3, and 4. With respect to scenario number 5, because of the cone of silence, I'm going to have to rely on council to provide guidance on how much information we can share, because that process is ongoing.
So the cone of silence is what would limit us from, unfortunately, we probably have the information, but because of the cone of silence, we're not able to use it to really inform the strategic planning process at this point. Is that a fair statement?
But this all becomes public if the process is completed by January 28th, correct?
It depends on how you conclude the process is the answer. So if the cone of silence is still in place, obviously the process is still protected. So I guess my question is what information is needed, I guess, is the question.
Yeah, so the question is, as we're evaluating these different scenarios, a lot of it is evaluating what is the value of JEA. As Councilman Beckton reminded us at the beginning of the meeting, JEA is owned by the consolidated government of Duval County. And so what we're doing is evaluating how do we provide the highest value to the consolidated government. And so do we have the information necessary to be able to make a reasonable estimate on that scenario number 5, which is the ITN process is designed to produce information for? So going back to my earlier question of, is the ITN a procurement process where we started a procurement process before we finished a strategic planning process, or is the ITN a information gathering process to inform the strategic planning process? And really what we're trying to finish is strategic planning. And so that we can, and I say that I'm a full believer of evaluating all these options and potentially others if there's there, because I think it's a very, very important question, and I think we need to fully evaluate that. But I think we can do it with reasonable information, not perfect information, if that is possible.
I would just like that. I think the importance of that question as well is that if this is a bid process, then this takes away the cone of silence and we get where we need to go. So we've been following this procurement process as though there is going to be an award, when in fact whoever comes out on top still, that may not necessarily be the option that is presented to City Council or turned over to City Council. So I think the question of whether this is a bid process or a procurement process is a valid question.
So the process is designed, it is certainly a government procurement. It's designed to present a best value option or decision to this board, and this board could move that forward for approval by the City Council and by addendum to the community. So it certainly is a procurement process, and it could result in a transaction.
It could, and then if the board decides to go in a different direction.
I'm sorry.
It's completely your discretion.
Even if the board decides to go in a different direction?
I'm saying, if the board, I'm sorry, I didn't finish that statement. If the board decides to go in a different direction, then the process could be canceled and be a notice of intent.
The board
not
could
to
choose
award.
not to advance the recommendation of best value.
So, Madam Chair, can we have a repeat on what's on the table as of today to vote on? Because I think that
No motion
I'm getting
has
some
been
information
made.
I didn't know, so I'd like to just.
Yeah, we haven't had a motion. The mayor made a recommendation that the board continue the process to include the ITN and to turn over all 5 options over to City Council to allow them to do their investigation and then make the vote if it should go as a referendum to the public.
Which, if Vice Chair, what you said was true, then that's what we were going to do anyway. Isn't that correct?
Well, we would have selected, please correct me if I'm wrong, our charge is to select one of the options over to City Council. But in the mayor's recommendation is to submit all 5 recommendations, all 5 processes, and allow City Council to pursue.
You go ahead, Henry.
And Madam Chair, my understanding, and I could be wrong, of the process as the way it's designed today is that the negotiating committee or management, someone will present to the board what they feel is the best option. They will present one option.
The negotiating team.
The negotiating team will present one option as a result of the ITN. I guess my recommendation, and I think this is somewhat aligned with what the mayor is trying to get at, if we do not suspend the ITN, if we move forward with it, it would be my recommendation that the negotiating committee present us with all options, or everyone who basically reached the finish line in that process. And I think the only way we can move forward with it is if they have confidence that they can have that completed by the next meeting, so that we can unveil this cone of silence and be able to have all the information. I also think that's important for us as we evaluate strategic planning to have more than the one recommendation, but that we have all options. So I don't know what needs to be changed to make that happen, but if we are going to move forward with this, it would be my recommendation that we make a change and instruct the negotiating committee to present us with all final options by the next board meeting.
Madam Chair, just to clarify, that is certainly an option. My understanding of the mayor's letter was to provide the top tier. So just for the board's consideration and just to clarify what the letter, I believe,
So that's
states.
Right.
the 4 options and the top 3 ITN bidders.
I believe the top tier referred to recommendations from the negotiation team, so just in the context of the ITN, and is separate from presenting the other options in strategic planning.
So I've been told several times when we ask questions about this negotiation process that it is no longer JEA's process, that it is the negotiating team. Are we in a position to make any changes to the process without them?
Can you answer that?
Madam Chair, so it would require an addendum to the ITN. So you can change the ITN, but would require a change to the ITN, which would be required to be posted for those respondents that are participating in the process to see, digest, and react to. So you can change the ITN process.
I'd also like to note that today we were going to review the co-op option as well, and we postponed that as well.
Right.
So we would be receiving, if we postpone this until January 28th, we would be receiving, if the ITN process, and you're feeling pretty confident that we could get there by the 28th, the ITN results as well as the co-op, and then still we still need the time to make the decision to turn it over to City
Right.
Council.
Madam Chair,
If we decide to go that way.
may I add to regarding Board Member Brown's question regarding having the information. My understanding is the intent of the process is to have all the information to present to the board, all the information needed. I think you were questioning, will we have all the information? I think all that is intended to be part of the presentation, once the process is complete.
And you said that we would have to revise the ITN and have to provide notice and whatnot if we made a change that the negotiating committee would present all options. Even if we went with the mayor's recommendation to present a top tier of options, we'd still have to make the same change. Is that correct? Or a similar change?
I think that's probably correct.
So regardless, even if we went with the mayor's recommendation, or if we decided because we wanted full transparency, we wanted to see all options, we'd still have to have a change and go through that process.
Yeah, I think so. I think the current process anticipates that you're going to review all options. For example, today I believe you were scheduled to review the co-op.
I don't mean all of the 5 options of the strategic planning process. I mean all of the ITN responses.
Understood. Okay, fair enough. Yeah, right. So the way the process is currently designed is that the negotiation team would make a recommendation of best value, which would be the best value recommendation, which is the result of the ITM process. And that's one recommendation.
And we would not have transparency into that, the other choices, basically.
You would have there's transparency into the process, which means you would have transparency into how the process went and the result, how it resulted.
But not the information.
All the information is
Everything opens up.
preserved.
All of the information.
Yeah, all the
So at that point in time, all of the options from all of the, I guess you can't call them bidders if it's an ITN, but all of the proposers, we would have all of that information of what their final proposal or final negotiated terms would have been.
Yes.
And we will have a recommendation from, but we could choose to, if we didn't like their recommendation and we think one of the other potential suitors was better, we could take that as our recommendation.
That is
or we
correct.
we could take that on for all.
That is correct.
Madam Chair, and so if we get the 5 options, or will we get the 5 options? I just want to make sure I'm clear on that. We would get all 5 options to make a decision on?
So only one option today currently will come from the ITN. I think what Mr. Brown is saying is we would
Excluding
want
that.
to see them all.
Yeah, but but what I'm hearing, I apologize if I'm naive to this, but there are 5 potential scenarios that we could look at. Will we get all 5 scenarios with an evaluation on all 5 and, the ITN being one of the 5?
Yeah, we have walked through scenarios 1, which is status quo. Ms. Dykes, if you'll walk us through those.
Yeah, scenarios 1 and 2 have been reviewed with board members already. Scenario 1 was status quo. Scenario 2 was the traditional utility response. Scenario 3 was ready for presentation today. That was deferred on the agenda. Scenario 4, there's still some work ongoing to complete scenario 4, which is the IPO scenario. I do expect that to be ready in the next 2 to 3 weeks.
But just getting back to my question, so are we going to get all 5 of them put in front of us to make a decision on one of the 5?
Yes.
Okay, and then my follow-up question to that is, do we present city council with 1 to vote on, or is it all 5 to vote on?
That's something we would have to decide. That's the mayor's recommendation to the board.
Thank you.
And then a follow-up to that, the 5th option, that's what we're talking about with the ITN. Under the current scenario, we would only receive the 1.
Under the current scenario.
Under the current
But
scenario.
are you asking?
I would like to propose that we modify the ITN so that the board receive all, I don't know, what's the proper term, respondents? that,
May I clarify? You would receive the recommendation of the highest value according to the negotiation team. You would also receive all of the information about the other respondents at that time.
including their names, all the detail, everything associated with it.
Correct.
So full transparency into all responses we would receive at that time.
Correct.
Okay.
Madam Chair,
Yes.
I apologize, but I do have a prior obligation, and I need to excuse myself from the meeting. Thank you.
Understood.
Thank you.
Be next.
Alrighty, so with that, are we comfortable with waiting until the next, to deferring this discussion for the next board meeting, since we know that that is a goal that the ITM process can reach? And then we will have scenarios 3 and 4 available at that time as well.
Can I just restate what I think you're saying?
Yes.
Okay. I want to be crystal clear as a newly appointed interim
Understood.
managing director that we're
Understood.
carrying out exactly what the board is directing us to do here. So what I'm hearing is we will, and you didn't say this, but I'll maybe add it for some clarification. We'll go back and relook at scenarios 1 and 2, and perhaps add in scenario 2 some charter changes and the analysis of those charter changes that we can incorporate into that scenario to be able to present those results to the board. We'll also have ready scenario 3, which was ready for presentation today. We'll present that in January. Scenario 4, we'll finish the analysis on the IPO scenario and have that ready for presentment at the January board meeting. And what's the specific direction on the ITN?
I think that it should be finished.
It should, well, yeah, we were told that it could possibly be finished, but I think to Board Member Brown's point is that we will want to see everything, not just the one recommendation.
Okay, thank you, that's clear.
And can I ask for one more recommendation to management or from management?
Absolutely.
That at the time, I think it would also be helpful to, and I know this may be challenging since you're will be new under this role and have a lot to do over the next month. I think we also, as a board, need to see what are the no regrets moves that JEA should be making, because as a board, we have no control over what city council decides to do and ultimately the voters decide to do. So I think it's really important that no matter what form JEA takes into the future, that we're working on the important things today that make JEA the best possible organization it could be, whatever form that takes. So I think at that point it would be important to understand, regardless of what happens, what are the no regrets moves we should be making today to make JEA the best organization possible.
I'm happy to present that as well. We did identify some through the strategic planning process that we've already made moves to implement, and so I'll share that with the board in January.
Great.
One additional clarifying question, if I may. The mayor's letters also asked for a sixth scenario to analyze moving JEA into a department of the city of Jacksonville. Is the direction from the board to complete that scenario also by January?
I'll take board comments.
I'm opposed to that. We've created an authority for a reason, and I think we need to keep it that way.
I would also be opposed to that.
I'm opposed to that as
opposed to
well.
it, too.
Board Member Flanagan?
I think we have limited time and resources, and our staff's time is probably best spent on the existing framework.
I agree.
Thank you.
Any further discussion regarding the strategic process exploration? All righty. Let's move on to old business. Sorry. No vote.
There's no vote required?
It was just discussion. Oh, actually, we do have it listed as action.
Madam
Yeah, I
Chair.
mean, I think, Melissa, would
Yeah.
you prefer to have clear direction from the board by way of a motion telling you to carry out these things?
As council, do you recommend that we
I
get a
would.
motion to formalize it?
I would.
Can you
So,
word the motion, please?
Yes, I believe the discussion that would be eligible for a motion is direction to the JEA management in preparation for the January 28th board meeting to present scenario 1, including no regrets discussion, scenario 2, including potential charter changes, scenario 3, the co-op, scenario 4, the IPO option, and scenario 5, which would be the negotiation team's recommendation coming out of the current competitive solicitation ITN process. I believe that's it, the direction of this board.
Can we get a motion?
So moved, Madam Chair.
Second.
Any discussion, any further discussion? All in favor indicate by saying aye.
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 Those opposed do the same. Motion approved. Thank you again, Melissa. We're going to move along pretty quickly here. Oh, any old business to discuss? Any new business to discuss? Mr. Gray being the new guy
You
at the
don't want my
table?
list. I'll come back.
Okay. Alrighty, and due to the sunshine, we're all under the sunshine. Any open discussion we'd like to have as a board? I think we've done it, right? And for my report, I'll keep it short and sweet. I'd just like to apologize on behalf of the board to the employees of JEA who may feel uncertainty by the heated discussions taking place in the community about the utility and their future. The men and women of JEA are dedicated and hardworking. Many of them put their lives on the line every day to serve our customers. I offer no excuse or attempt to explain. We should have done a better job of shepherding this process and discussion. A discussion that we absolutely must have as a community, but one that we could have been and should have managed better. That apology is also extended to our customers. You also deserve more information sooner from JEA rather than the media. I thank everyone for their time today. Meeting adjourned.